Good afternoon. Welcome to the Appellate Division First Department. We have oral arguments for today, April 21. We have eight and 1/2 hours of argument time requested. So please ask for the time that you actually need in order to get out the salient points of your arguments. Please keep in mind that we are familiar with your arguments. We have read the briefs. First case, People v. Marlon Alvarez. That matter is submitted. Parker v. Simmons, submitted. Matter of Christina, submitted. Chaw v. Ryder Truck Rental, submitted. Merc Property Holdings v. Gelfand, Yes, sir, I'm sorry. There's no one to reply to. I'm sorry, but I'm saying you asked for reply time. There's no one to reply to. There's no one is here. Okay, so we'll give you 3 minutes. People v. Fafana. (414) Rojas v. 444-451 Orange Buildings. That matter is submitted. Adamus v. Galaxy General Contracting. 5 and 2, but it doesn't matter. 525. People v. Guiti, submitted. Tilly v. New York Presbyterian Hospital. 525. Urban v. Roman Catholic Archdiocese. 525. People v. Ashley Simmons. That matter is submitted. Weiner Realty Management v. One Penn Plaza. 523. Dusa v. El Sol Contracting. 525. France v. XL Diamonds. 525. Foulas v. Weeks Wasman. 424. Gurr Associates v. Cassim. Repellent. Were you running late? Were you the respondent on this one? No, but did you tell us you were running late? Was that him? Oh, okay, thank you. 525. Kingdom Associates versus WBC. 525. People v. Santana. 524. Rapaz, New York City v. Asa Properties. Matter submitted. The will of George S. Kaufman. Okay, I didn't have any time. I'm sorry. Yes, 5 and 2. And he's just standing there? Oh, okay. Okay. He didn't have to get up. Thank you. First case to be called is Merc Properties Holdings. Well, you're quick. Wait a second. One minute. Okay, go.
May it please the court, my name is Tom Lambert from Lambert and Shackman for the Tenants Appellants. In case it's required to disclose for judicial notice, on April 15th, this case was dismissed by the court below for failure of the landlord to appear at a compliance conference. We are appealing from that because we're entitled to judgment on the merits on our counterclaims and also on the merits dismissing the case, the complaint. Now, the judge below correctly.
Councilman, go ahead.
I'm going to jump to an issue. Was there a rent demand in this case? Was there a
Yes.
14-day rent demand?
No.
Isn't that a condition precedent to the filing of an action, of a proceeding?
Yes. That's a basis to dismiss the rent claim right there. That's right. You know, the judge below correctly denied the motion to dismiss based on default in pleading. There was 2 pleadings. There were cross motions for summary judgment. He correctly decided the case based on the merits of the cross motions, but he incorrectly decided those cross motions on the merits because he decided them contrary to all of the evidence. There was no cognizable evidence put in by the landlord, and there was sworn prima facie proof put in upon personal knowledge and with documents of the tenants. And I have nothing further to say unless there are further inquiries, but that's the beginning and end of it,
Any questions?
I believe.
Thank you very much. Have a
Thank
good
you.
day. People v. Fafana. Yes, whenever you're ready.
Good afternoon, and may it please the court. Jalen Banks, law graduate, on behalf of appellant Jagiba Fafana. Mr. Fafana's 18-year sentence is excessive, given his completely law-abiding life prior to the instant offense, laudable military service, and traumatic childhood. A reduced sentence would fully serve the aims of the penal sanction and is warranted in the interest of justice. Additionally, the appeal waiver is invalid and should not stop
Oh, yes, why is the appeal waiver invalid?
Yes, Your Honor. 4 points on that. Number one, Mr. Fafana's signature on the waiver form came prior to the court's explanation on the consequences of waiver. Number two,
Have we addressed that issue before?
no, Your Honor. But ultimately, the second department,
No.
Department. And I think that we have addressed that issue before in terms of when the signature comes. What do you want to focus maybe on the colloquy? Is there something wrong there?
your point is well taken, Your Honor. The second point that invalidates the appeal waiver is that the court failed to make clear that Mr. Fafana had a right to counsel on appeal. That's an issue in the CJI language. And then number three, Mr. Fafana had never been arrested prior to this offense and had no previous contact with the criminal.
Prior to killing the decedent.
Correct, Your Honor.
So it's not exactly an offense.
Your point is well taken, Your Honor. This was a severe crime. However, Mr. Fafana does take full accountability for his actions and has expressed his sincere remorse. And so the fourth and final point I would like to reach on why the appeal waiver is invalid.
Sometimes I confuse these cases. Was this the one where the wife of the deceased was in the courtroom and he didn't say anything to her?
Yes, Your Honor.
Oh, okay. I wasn't sure whether I had confused the case or not. So she made a statement, a victim impact statement concerning what this had done to her, but he did not address it, right? He didn't say anything. He never said, you know, I'm sorry for killing your husband as a result of road rage. I'm sorry for shooting him once in the thigh, and then as he attempted to drive off, the deceased attempted to drive off, running after him, chasing after him, and then shooting him in the back. He didn't say my apologies to you and to your family.
2 points on that, Your Honor. While Mr. Fafana did not make a statement at sentencing, he did express his remorse by sympathizing with the family of Mr. Guerrero and expressing his deep regrets for his actions during the pre-plea interview.
I sidetracked you because my colleague had asked a question concerning the plea waiver, and I'm looking at the waiver. And you stated that there was no statement made to the defendant that he had a right to appellate counsel.
That's correct, Your Honor. Ultimately, this is an issue in the CJI language, especially for an individual like Mr. Fafana, who immigrated to the United States when he was 23 years old and was not familiar with the American legal system.
Again, apologies if I'm confusing the cases. Was he not in the military?
He did have an exemplary career in the United States Navy, Your Honor.
I just wanted to be sure.
Absolutely. But ultimately, and again, the final point on the appeal waiver is that the court's colloquy came after the allocution and admission of guilt.
Haven't we addressed that issue as well?
Specifically, because, and you mentioned the second department. The second department now follows us, right? Because we stated that it's not an issue. We are initially the second department had said it was, and then they came around to our way of thinking.
Right, Your Honor. But I just wanted to point out that this issue is currently pending before the Court of Appeals.
Actually, in People v. Brown, a case that we decided in 2024, leave was denied by the Court of Appeals on that issue.
Yes, Your Honor. The Court of Appeals has granted leave on this issue now, People v. Howard and People v. Cheriston. So it is an issue currently pending before the Court of Appeals, and that's just to underscore the fact that reasonable jurists do differ on this issue, let alone, again, someone who immigrated to the United States when they were 23 years old, and again—
And then joined the military. Thank you so much. You have time on rebuttal. Did you want to address the waiver?
Yes, good afternoon, Your Honor. ADA Joshua Hansen for the people pursuant to the practice order and under the supervision of ADA Aldridge. First, to address the waiver, the defendant's waiver of appeal in this case forecloses the review of the excessive sentence claim. The defendant's waiver to the right of—
Well, if the waiver is invalid, how does that affect the excessive sentence review?
Your Honor, that would, if the waiver was invalid, it would allow the court to reach the
So
excessive
let's talk
sentence.
about whether or not the waiver is valid or invalid. Your adversary has put forth one argument that the fact that the defendant was not informed of his right to appellate counsel invalidates the waiver. Do you have a response to that?
Yes, Your Honor, I would submit that the court properly advised the defendant of his right to appellate counsel. The sentencing court used almost verbatim the language from the criminal jury instructions. The court told the defendant on page 12 of the transcript that if you could not afford the cost of an appeal or of an attorney for that appeal, the state of New York would bear those costs.
And the other issue that your adversary raises is that the waiver was signed prior to the plea being entered. Do you have a response to that?
Yes, Your Honor, as this court has decided, it may be better practice to go into the oral colloquy of the appeal waiver. However, that simply does not invalidate the waiver altogether.
Are there any mitigating factors that were not addressed or known to the trial court at the time when they imposed the sentence?
No, Your Honor. In this case, the sentencing court was able to review all of the mitigating factors that defendant now points to. There was a pre-plea information in this case pointing out the defendant's childhood and the defendant's mental health history, his employment, and his criminal history, and all of that was before the sentencing court when they decided to impose the negotiated and bargained for sentence.
Thank you.
So turning to the excessive sentence claim, this defendant's sentence was fair and proper for turning a minor fender bender into a homicide of Mr. Guerrero. All of the—
Maximum that he was facing.
He was indicted, the defendant was indicted on second-degree murder and could have faced 25 years to life in prison as a result of that.
And he got, what, 18 years?
18 years and 5 years of post-release supervision, Your Honor. And for those reasons, we would submit that the sentence was fair and proper for the killing of Mr. Guerrero.
Thank you.
And thank you, Your Honor.
So, counsel, just to pick up that thread, he was facing a maximum of 25 years and he got 18. What is it that you're asking us to reduce it to?
25 to life.
25 to life.
Your Honor,
Flat 18.
Your Honor, we would ask that the court reduce Mr. Fafana's sentence to 10 years. That's double the minimum that he was facing, especially considering, again, the exceptional merits of Mr. Fafana's case. The incident offense was truly aberrational. Mr. Fafana is a peaceful person who has overcome unspeakable horrors.
Didn't he have time to reflect in the sense that He shot the decedent 2 times.
He chased after him. So between the first shot to the thigh and then running after him, running after the deceased, couldn't he be reflected at that point in time? Not even the fact that after this fender bender, he could have reflected by not reaching for the loaded weapon that he had brought, I think, from Pennsylvania,
Yes,
to shoot the to shoot the deceased.
Again, your point is well taken. Mr. Fafana recognizes that his conduct was unacceptable and was an impulsive overreaction based in the childhood trauma that he sustained. But ultimately, again, he does take full accountability for this. And to one point that my colleague said, ultimately, the court below did consider the mitigating circumstances in Mr. Fafana's case. But that is why this court has de novo review authority, because sometimes the court below does consider the information before them and come to a decision. But ultimately, intervention from this court is warranted because of the rare merits in Mr. Fafana's case.
Thank you. You said you're a law graduate?
Yes, Your Honor.
What law school did you graduate from?
NYU Law.
Oh,
I'm sorry.
we're both. Excuse me. We're both NYU law graduates. So
Go Violets.
you can tell that was an excellent argument. Excellent. Oh my goodness. No, thank you all. And also, you're waiting admission to the bar. Okay. So what law school did you go to? Okay. But you both did a great job. Thank you very much.
Thank you.
Adamus v. Galaxy General Contracting.
Good afternoon, Your Honors. May it please the Court, Kenneth Gorman for the Plaintiff Appellant. Galaxy failed to meet its burden for summary judgment. The only evidence it submitted was a self-serving affidavit from its corporate officer who had
Oh, we have photos? We have photos, right?
photos.
Did the photos kind of show where this is alleged to have occurred?
Excuse me?
Does the photos in any way show where this incident is alleged to have occurred?
I believe it occurred in front of CJAN's business on 3497 3rd Avenue, on the corner of it. And Galaxy's whole argument was that because it didn't own the property in front of 3497 3rd Avenue, that it wasn't responsible. But we can't overlook that it did roadway excavation work spanning from 167th Street to 168th Street. There's no evidence that its roadway excavation work stopped at the property line of 3495.
So here's the
3rd Avenue.
problem that I have with that argument, counsel. I took a hard look not only at the photographs, but also at the permits. And the permits reference 3rd Avenue, which is the location of Galaxy, right? And it says on street 3rd Avenue from street 167 to 168. Now, we know that permits are very, very specific, right? If you go outside those boundaries, you're going to get ticketed. Nothing here shows a nexus between, what street was it where the accident took place?
It was
160,
168th and 3rd.
168th. Where's the nexus?
The corner, southeast corner of 168.
Assuming it was, yes, southeast corner of 168th. This was roadway excavation work. It wasn't a small project. I mean, the whole.
But the I'm sorry, the location of the Galaxy properties, the lot and the building, are not at the corner. So is there anything from an expert from the city, a map, anything, that shows that the work that they did went beyond the expanse of what they owned?
We had no opportunity to conduct discovery. I mean, Galaxy ignored our discovery demands. It moved for summary judgment 3 weeks before the preliminary conference, and it relies on Mr. Seeker's affidavit, who admittedly has no personal knowledge of the
Can I
roadway excavation.
ask you a question about that affidavit? Was that argument as to no personal knowledge, was that raised below to the trial court? Or are you bringing it up now for the first time on appeal?
Well, the requirements that affidavits be supported by personal knowledge is statutory. CP law.
So you don't have to raise it? Is that your
I mean,
position?
well, you have to meet your burden initially. I mean, if you don't meet your burden, it's not, the plaintiff's opposition papers don't have to be considered. I mean, CPLR 3212B states that a motion for summary judgment shall be submitted by an affidavit by a person having knowledge of the facts, which Mr. Sika did not have. Based on that, they failed to meet their initial burden in the first place.
Let me ask you a different question, and I don't know that there's an answer, all right? So is there any expert who says that the work that was conducted by Galaxy went beyond Third Avenue?
No expert, but, I mean, we
But
didn't,
Sika's
have that-
affidavit states that, right?
excuse me?
Sika's affidavit states that it did not go beyond, right?
Based on nothing. I mean, he had no personal, he based it on the permits that he submitted. Those permits I mean, they're conflicting. They say that the work area spans from 168 to 167 to 168th Street on Third Avenue.
No, you've got it backwards. It's on Third Avenue from 167 to 168.
Correct. And
These permits are very specific. If it had let me just stop there. Go ahead.
at the very least, we should have the opportunity to conduct discovery and find out what Galaxy has. I mean, Galaxy moved for summary judgment, and it kept the discovery it had and didn't disclose it, and we were at an extreme
Perhaps
disadvantage.
we'd be in a different situation if the building was at the corner where the property was on both Third Avenue and 168th Street. But to the extent that it's on Third Avenue and it's buttressed by properties, we have a different situation, don't we?
If there was a motion to dismiss and it was based on documentary evidence, I would understand, but this is a different standard, and we, at the very least, should have the opportunity to conduct discovery.
Well, what
on this
about
issue.
some type of expert affidavit stating that the work that was done in that area could somehow carry over to the area where the accident is alleged to have occurred?
We didn't have access to the documentary evidence that Galaxy had in its sole possession, so we couldn't have submitted an expert affidavit at this early stage. I mean, this
But
was.
you had Sika's affidavit, so you know what Sika was stating, and you had the permits in terms of when the work was actually conducted.
First time Sika submitted his affidavit was when they moved for summary judgment.
But you knew where you did have the information as to where the work occurred.
We had permits, but permits don't constitute the evidence that we needed to make that determination. Just based on those permits, we can't dismiss plaintiff's case. I mean, at the very least, we should be able to depose Sika or anybody with personal knowledge with regard to this construction roadway excavation work that expanded the entire block,
You have time on
167.
rebuttal, thank you.
Thank you.
Good afternoon, Your Honors. Plaintiff initially raised that they had no time to address this issue.
Counsel, make your appearance first.
Oh, my apologies. My name's Anna Schuline. I'm from Chartwell Law, and I represent Defendant Galaxy, the respondent in this appearance. Okay, plaintiff's accident occurred on November 10th, 2021, and they did not bring this case till 2023. Almost a year later, there was no preliminary conference at that time. And we got the initial discovery responses that included
How is
witness
this
statement. Sorry.
relevant to the fact that your person who submitted the affidavit does not have personal knowledge?
He does have personal knowledge. He is the vice president of Galaxy.
Well, let's rephrase it. The affidavit does not state that he or she has personal knowledge. It doesn't say the basis for the statements in the affidavit.
Thank you.
So we don't know that the individual has personal knowledge. You're telling us that as the vice president, you stated?
Vice president of the.
But even then, I don't know that that would clear up the issue as to whether he or she had personal knowledge. But
Yeah, the problem is that at paragraph 1, he says, I am the vice president for Galaxy. But then at paragraph 2, Mr. Sika says, I have been advised by counsel for Galaxy. And then it goes on. So there's no differentiation there.
He was advised by counsel of plaintiff's alleged accident, but he had the personal knowledge of what property Galaxy owns and admits to the property that is owned, which is nowhere near plaintiff's accident. It's completely catty corner and in the middle of the block. Plaintiff's accident happened in the roadway between 3rd Avenue and Washington Avenue on 168th Street. That is not next to or adjacent to the property that Galaxy owned. The permits were passed by the city over 2 years prior to this accident occurring.
When you say passed,
Yes, the city,
the permits were passed or the inspection?
the
They got a
inspector
pass?
passed the permits and the
Or
work performed
the
pursuant to
inspection.
them. Yes, and it's signed off by Kevin Cherry. He inspected and passed the work that was performed pursuant to these permits that plaintiff submitted in their opposition to our papers.
But is that enough at this procedural juncture to put the plaintiffs in the position of essentially accepting your client's word for the scope of the work? Mr.
Sika,
Sika is certainly able to set forth the extent of the scope of the property. He can authenticate the city permits, but as to the actual expanse of the work and wherever that work occurred, whether it may have been contributed or caused the allegedly defective condition, are we putting the plaintiff in an unfair position here?
I don't think so, because there are Google images that date back years that show the defect that plaintiff alleged caused her accident that pre-exist any of the work of the permit, which again is not in the same position. As you previously stated, the permits are pretty direct in what exactly they encompass, and it's a 30-feet zone. Plaintiff's accident happened approximately 167 feet away from the closest point on the Galaxy properties. So I think plaintiffs had enough to go off of from that.
Thank you.
Thank you.
Justice Higgitt's questions hit the nail right on the spot. The case law from the Court of Appeals and this court clearly state the cases that we cite at pages 4 and 16 of our main brief and throughout a reply brief state that affidavits from corporate officials who have no direct knowledge of the facts are insufficient to support summary judgment. And the Google images that they're relying on were not in the record.
Counsel, to be fair, did you make these arguments below?
Which
Arguments you just stated with regard to the affidavit?
no.
You're really making it for the first time here.
They have to meet their initial burden. And as I said, I mean, CPL law 3212 clearly states that a person moving for summary judgment has to have an affidavit with a person from knowledge. And Mr. Sika did not have personal knowledge. And based on that, in Garcia versus Bureau of Manufacturing Company, 63 NY2D 751, the Court of Appeals clearly states that an affidavit from a corporate official without personal knowledge is insufficient to meet a burden for summary judgment.
I'm looking at the photographs again. These are part of the letter sent on May 24th, 2023, showing, let me say from whom, from Counsel for Galaxy to, I guess it was your firm?
Yes.
Okay, and they have photographs and a very detailed narrative saying this simply didn't happen here. There does appear to be a tripping hazard in the roadway at the bus stop, but the work was performed someplace else. So surely there was enough time for the documentation to be amassed on your client's end to show that there was some nexus between the accident and the location.
Our client tried to. I mean, it serves combined discovery demands, and before Galaxy complied with them, it moved for summary judgment. This is the letter from an attorney with pictures. It's not sufficient to meet a burden for summary judgment to non-sue plaintiff at this juncture. All we're asking for is an opportunity to conduct discovery.
Thank you. Thank you
Thank you.
both. Philly v. New York Presbyterian. Yes, you may proceed.
My name is Diana Sen, and I'm a pro se counsel for plaintiff appellants in this case. May it please this court. This case is about a mother who was banned from seeing her newborn baby for 5 long days in the neonatal ICU at New York Presbyterian Hospital.
Counsel, is this case about not having a reasonable accommodation to, like a separate room to maybe manage the situation of the disability of the asthma? Is that what you're really talking about here?
Yes, Your Honor, that is a large part of the case. It is required to have an interactive process when a reasonable accommodation was requested.
So did you request that? Did you request a separate room where you could actually nurse the child?
Yes, Your Honor.
And was there a response at all to that request?
There was no response. In fact, I disputed being ill because I had asthma, and I was banned from the NICU. I asked for their policy and practice. They did not give it to me. They banned me for 5 days.
And so just to move beyond that, are you seeking damages or a declaration?
Yes, Your Honor, I am seeking damages. I am also seeking a declaration so that this doesn't happen again.
So what declaration is it that you're seeking?
That one, if there is a mother that is banned from seeing their newborn son at the NICU, a place of public accommodation, that they, one, not only be given an interactive process and a reasonable accommodation if available, but two, that they are not banned from being able to see their child because they are Hispanic or because of their disability or for retaliation for complaining about the discrimination.
So what was the retaliation?
The retaliation was, one, I had complained about the medical care my son was receiving.
No, how did they, so you're stating that because of your complaints about the care that your son was receiving, they retaliated by not allowing you to nurse him?
Yes. So I was.
And that's based on what?
I was complaining about the medical care that they were providing him. There were bloody sharps on the floor. He was not given the breast milk properly.
Is that a discrimination claim under the HRL? I mean, that might be a separate cause of action, but underneath the HRL, is that a discrimination claim?
Yeah, so under the New York City human rights law, there's retaliation. And so there was retaliation when you complain about discrimination. And one, I
Right,
was
so
complaining.
what was the, so you mentioned sharp objects on the floor. You mentioned the medical treatment that your son was receiving. So how does that tie in to any type of discrimination?
So there's that because my son is Hispanic as well.
So I didn't see that in the complaint. So you're alleging that your son was not given proper medical care because he is Hispanic?
Yes, he was treated poorly because he was Hispanic.
And what is that based on?
The treatment of other children at the NICU.
Okay, again, I didn't see that in the complaint. Maybe,
Yes,
perhaps
and
I missed it.
also the.
Well, where did you state that in the complaint, that there were children who were non-Hispanic or not Hispanic or Caucasian who were treated differently, better? I saw something, there was an allegation concerning a mother who was Caucasian who you stated was coughing, and yet still she was allowed to go into the NIC unit. But I didn't see anything about treatment of Hispanic children being different from the treatment of non-Hispanic children in the unit.
Yeah, so that wasn't specifically in the complaint, Your Honor. I mean, the child is Hispanic.
Is that a problem, Ms.?
Right.
Is that a problem, Ms. Sen?
No, Your Honor, because the
Well, I mean, we're at a
retaliation
pleading
didn't
sta-
only stem
We're
from
at
that.
a pleading stage here, right? And so you have to plead these things with, I don't want to say specificity because we're not there, but because we are going to interpret it liberally, but you have to at least allege those facts. And as my colleague pointed out, that particular scenario is not in here, where there is with the coffin and someone else being allowed to go in, another mother, a Caucasian mother, as you've alleged, was allowed to go in, and you were denied maybe this reasonable accommodation, because even if you were coffin, they should have put you some other place for this. But what you're saying right now is not in your complaint. And you didn't move to amend your complaint.
Yes, Your Honor. Well, one, I was not given the opportunity to amend the complaint. I was dismissed immediately without opportunity
Did you need
to
leave?
amend.
Did you need leave to amend?
I did not.
Oh, well, you said you weren't allowed to amend, so that's.
Well, I mean, my case was dismissed without the opportunity to amend. So the judge dismissed the case immediately. But Your Honor, I wanted to make sure that the retaliation that is alleged in the complaint does relate to the fact that the mother who has asthma complained on the spot about being banned because there is no such policy and practice in place, and that there was discrimination, not only because she was Hispanic, but also because she had asthma, and that she did not have a cough.
Again, I'm trying to figure out what the retaliation is. What did they do in order to retaliate, or because of statements that you, what is the retaliation? Is that barring you from seeing your son?
Yes, so the retaliation is, one, they not only banned me, but two, after their own ER doctor cleared me to come back and see my son and to nurse him, they banned me for an additional 3 days after that. It is that retaliation. It is for complaining about discrimination, for complaining about wanting a reasonable accommodation, not getting an interactive process, of which I did complain about at that time.
I have one more question.
Yeah, go ahead.
So just going back to your complaint and the way that it's formatted, you have the breach of contract, the unjust enrichment, the infliction of emotional distress, and then this cause of action for declaratory judgment. At this point, would it be appropriate for a declaratory judgment, or are you just trying to have your pleading survive, a 3211 kind of motion?
Yes, Your Honor. I think the point is that the New York City human rights law is supposed to be as broad and remedial as possible. So any type of defects in the pleading, so long as within the four corners of the document states that there is discrimination and retaliation, I think that's key. The breach of contract claim is because the hospital took over $100,000, did not allow me to see my son, also did not let the baby breastfeed and be with his mother.
Thank you. You have time on rebuttal.
Okay, thank you.
Good afternoon, Your Honors, and may it please the court. Matthew Berger, Baker Hostetler, on behalf
Can you pick up the mic a little bit so we can hear you better?
Matthew Berger, Baker Hostetler, on behalf of defendants, respondents.
Does this properly lie as a motion for declaratory relief?
Excuse me, Your Honor?
Does this properly lie as a motion for declaratory relief? Is it properly brought for such relief?
Respondent's motion?
Yeah. Yes.
Yes, Your Honor, because on a 3211 motion, if the court treats all facts as true, then it's not making a factual determination. It is making a determination based on law. And that is what the court did here. On a 3211A7 motion, the court treats all facts properly pled as true for purpose of the motion.
So let's address the issue of the claim as to failure to provide reasonable accommodation. Okay, so you have a mother who presents with cough in a NICU, and we know that the preemies are at risk. I mean, that's
exactly
public
right.
knowledge. We don't need anything besides that. Okay, she's told, go get clearance. She gets clearance from the same hospital, and the RVP test also comes back negative, and she's not allowed to breastfeed her child in a private room as requested. How does that comply or not comply with the city human rights law?
Well, to start with, Your Honor, the plaintiffs didn't plead these claims in the complaint. There are 4 express causes of action, none of which...
I thought she did plead, again, maybe a little inartfully, but she did plead and state that she was not afforded an accommodation.
She included those as her factual allegations, but the express causes of action were breach of contract, intentional infliction of emotional distress, unjust enrichment, and declaratory.
Well, let me ask you a question, because while the heading part might say one thing, and underneath where the cause of action is described says another thing, which would lend to her failure to give an accommodation cause of action. How do we reconcile that? Is there a way to reconcile that, or does it require an amended pleading?
To the extent that the court, even if the court were to read into the complaint causes of action under the New York City human rights law, they're still subject to dismissal for two reasons. First, they're untimely under the.
Why are they untimely? Wasn't the closure of the human rights complaint in 2021 as opposed to 2020?
That was, no, that was the corrected notice, Your Honor. The actual.
They made a
original-
mistake, right?
But it didn't, the change in the reason for the closure did not affect any of the plaintiff's substantive rights. As of December 28th, 2020, that's when the case was dismissed. The fact that there was a typographical error does not restart the statute of limitations or change the statute of limitations date.
2021?
2020 is when.
2020 was the mistake.
2020 was the mistake, January 8th,
And 2021 was the correct
corrected,
date. And you're saying that 2021 was problematic? The time?
2020 was problematic.
Right, but it's 2021. If the correct date is
If the
2021,
correct
do we
date
have
was
a problem?
2021, I still don't believe there's a problem, because the statute is running from December 28th until
You
the
still
corrected
don't
notice.
believe there's a problem? That means there's no problem?
Yes, Your Honor. No, there still is a problem, Your Honor, for plaintiffs. But even putting aside the untimeliness, the complaint still fails to state a claim, because the allegations, the non-speculative allegations, which a court is not entitled to give to a presumption of truth on a 3211A7 motion, the non-speculative allegations, the material allegations that are left, do not state a claim that Ms. Sen or her son were denied public accommodations on the basis of either their race or any alleged disability.
Well, the disability I think alleged is having asthma, which was manifested in the form of a cough. And when the testing came back, she was still not allowed to see her son and breastfeed him.
Well,
There was nothing to be done. There was nothing done. There was no interactive conversation.
if we're
That's the allegation. Why isn't that enough?
if we're looking at the allegations of the complaint, Ms. Sen received what she claims is a clear bill of health from the ER department and then presented it to,
The same hospital?
yes, but not
So you're saying that the
Dr. Chang, her son's doctor, who has a primary responsibility for his care, made the determination that she was not yet cleared to come into the NICU.
But wasn't she also directed to see her obstetrician?
Yes, to get clearance to see her child in the NICU.
Who was the obstetrician?
It's not pled in the complaint.
Okay, so you're saying that wherein she might have been cleared, the child wasn't cleared because
Yes, that's
Dr.
right.
Chang.
There are two parties here, Ms. Sen and her son, who is in the NICU. Several days later, he was released and able to go home, but at that time, he was still a patient in the NICU.
So did Dr. Chang ever state to her that there had to be, that he was not clearing the child and there had to be something else in order to clear the child?
That's not pled in the complaint, but it is pled that she had to get clearance from her.
Where's the affidavit from
Yeah.
affirmation from Dr. Chang?
This is on the four corners of the pleading, Your Honor.
I'm asking you something different, which is to say, who knows what happened here with respect to Dr. Chang's thinking? Because if she's cleared and the baby has to be cleared, don't we need something that says that?
Well, that part is pled in the complaint, that Dr. Chang directed Ms. Sen to get clearance from the OB to be able to come in and see her child.
But the reasoning that you're saying behind it is something that would maybe come from a discovery phase and not necessarily we're at a 3211 motion. So how is that relevant here? If it's pled, then let it move forward to discovery, and maybe on summary judgment, there's a different outcome. But here,
It's specifically not pled, as the lower court correctly found.
No, again, it may be inartful, but she states that she was told that she was to get clearance. She had to take the test. She took the various tests, she was cleared. And then when she went back to say, I'm cleared, and therefore I should be able to see my son and nurse my son, they said no. Then she asked for a separate room, an accommodation. They said no. That, coupled with the fact, which she does plead, that there was a female Caucasian who also had a cough but was allowed to stay. So taking all of that together, why is it not enough?
Just as Your Honor stated, so after she brought the letter and said that Miss Sen was cleared, Dr. Chang said, you need to get clearance from your OB. Right there, that has nothing to do with an alleged disability. It has nothing to do with race, okay? So then there is...
But again, looking at the four corners, how do we know that, given the fact that she does plead that there's a Caucasian woman with a cough who apparently is allowed to stay?
So that's a purely speculative...
How can that be speculative? She sees it with her own eyeballs.
Miss Sen says she sees a Caucasian woman, a woman Caucasian in appearance, who is allowed to go into the NICU.
Based on her own observation. So how can that be speculative? If somebody's got a cough, and they're, but if somebody walks into a NICU and has a cough and is breastfeeding, how can you call that speculation?
Well, what she observed with her own eyes is not speculation, that she saw a
Right.
Caucasian woman walk in.
Right.
But there is nothing to suggest that the hospital saw this Caucasian woman coughing and let her in anyway.
You hear coughing, counsel.
But the four corners of the complaint, Your Honor, does not say Miss Sen saw a Caucasian woman walk in and then saw Dr. Chang look at the woman and then let her
I mean,
in.
that's really specific, right? Because all of that information might come from discovery, but in terms of what her burden is at the pleading stage, and again, it's maybe not the most artfully crafted complaint, but why isn't there enough in here to at least allege the fact that there was this discrimination in the form of lack of accommodation?
Because as the trial court...
She's alleged the comparator, right? She's alleged that she's a person of Hispanic race, that she had a disability, and that she was not afforded accommodation in the way after she had given birth to breastfeed her child. Why isn't that enough?
Because she's not connecting the decision to remove Miss Sen from herself from the NICU to her race or to her disability. The fact
And
that
what was the point of getting further testing? What was it? Right, because her disability, she's saying, is asthma, which manifested in the form of a cough.
And as pled in the complaint, Mr. Tilley's, the baby's doctor, requested further clearance in order for Miss Sen to be able to come into the NICU. That is, you have to look at Miss Sen's position and then Tilley's position, right? There's two parties here, and the
So when you say Tilley, you mean the father or the child?
the child.
The child. So we can call him William, please?
William,
It's
sorry.
easier.
Yes, William.
Okay.
So Dr. Chang was William's primary physician. And if you're looking at the complaint, it reads as if the primary care physician for William is concerned for his safety and well-being and directing Miss Sen to get further clearance. That has
She brought her complaint individually, not just on behalf of the child, right? So does that
both.
matter?
Both.
No, because, Your Honors, when you're asking about this request from Dr. Chang to send Miss Sen to her OB to get further clearance, we can't just look at it in a vacuum based on what's alleged in the complaint.
I'm thinking about how much information can you provide if you don't have discovery? I mean, my colleagues are saying, all of us are saying the same thing, right?
Absolutely.
Without discovery, you can describe what you see. You can describe what you heard, but you can't really go beyond that because you don't have enough information.
And that's exactly.
And Dr. Chang has nothing here to explain what he was thinking or doing.
Well, that's exactly, the burden is on the plaintiff to plead enough to get past. That's the whole purpose of a 3211 motion, is to test the legal sufficiency based on the allegations in the complaint.
In light of Justice Pittsburgh mentioned the presence in the complaint of allegations relating to a comparator. So would a reasonable inference, not necessarily the ultimate inference a fact finder would draw, but would a reasonable inference be that there was a discriminatory motive behind the manner in which plaintiff alleges she was treated?
That Miss Sen personally observed a white woman walk into the NICU coughing. It is pure speculation that the reason that that woman was allowed in was because of the color of her skin. And as in Sonkin v. Sonkin, 157 AD 3rd 414, the First Department has said speculative allegations are insufficient to state a claim of discrimination. And that's exactly what we have here.
And that's a very fair point. I guess Justice Gonzalez just mentioned that the plaintiff is to some extent, operating with blinders on. She knows what she saw or observed. That's what she could attest to in the complaint. And again, in light of the 3211 posture, we do have to draw all reasonable, favorable inferences in the plaintiff's favor. So again,
Non-speculative allegations. On conclusory and speculative allegations, you do not need to draw a reasonable inference. I mean, the reason why speculation is insufficient is because I could speculate that this woman, the Caucasian woman, had been tested and cleared.
As was she, as was Ms. Sen.
Not by her OB, not by Dr. Chang.
See, you're alleging things that would maybe come from discovery, because maybe there is this there's this legitimate non-discriminatory reason. But how can we find that just by looking on the complaint?
You can look at the four corners of the complaint and look at the non-speculative, non-conclusory allegations and see whether or not a claim has been stated that the actions by the hospital were because of Ms. Sen's alleged disability or because of her race. And the non-conclusory, non-speculative allegations do not rise to the level. That's what the trial court found, and it was the right decision.
Thank you.
Thank you, Your Honors.
Your Honors, yes, the complaint was inartful, but it was alleged all, and it was incorporated by reference. So I think for the...
Can I ask you, do you have a separate independent cause of action for discrimination under the New York City human rights law, or is it just a declaratory judgment and injunction request?
Yes, Your Honor, I do have a claim under the New York City human rights law.
So you're saying that fourth cause of action is really two causes of action?
Yeah,
One is under the New York City human rights law, and the other is based upon a declaratory judgment?
Yes, like it should
It's
have...
actually three, because yeah, actually for an injunction
Yes,
as
like
well.
it should have been the New York City Human Rights Law Commission law is being violated for discrimination based on race, disability, and retaliation, and that should have been in there in the heading. It is in there throughout the complaint. There's multiple references to the New York's human rights law, but it should have been there.
Your intention was to plead a separate cause of action for discrimination under the New York City human rights law. Is that correct?
Yes, Your Honor. Thank you.
And what are the allegations, putting aside the labels, what are the particular allegations in your present complaint that would manifest those city human rights law claims?
Yes, that I was banned from seeing my son for 5 days because I'm Hispanic. And that I was banned for seeing my son for 5 days because I have asthma and I have a cough that sounds different. And that even when I was cleared by their own ER doctor that cost $4,000 to see and a $2,000 RVP test, I was still banned from seeing my son for multiple days. And that I never had an interactive process. And what's key with the interactive process is you're supposed to talk to the person. So I demanded an interactive process from Dr. Chang She never once spoke to me in 5 days. She only spoke to my blonde Caucasian husband throughout, who is not a lawyer, about different things of, oh, you must see your OBGYN. Oh, you must have this test. Oh, you must go here.
any of
instead
this
having
Not
a
in the
plan.
complaint, I don't remember seeing,
Yes, Your Honor.
again, I don't, did you allege in the complaint that, because I was gonna ask what the comparator would be for the discrimination in terms of your being banned because you're Latina. Is there anything in the complaint stating that he was allowed to go in there, or that Dr. Chang only spoke to him?
Yes, Your Honor. And it's throughout, because I never
You
had.
stated in the complaint that
Yes.
Dr. Chang only spoke to him.
Yes, yes. And they never once spoke to me, which is the whole point of the whole interactive process. You're supposed to talk to the person asking for a reasonable
Thank
accommodation.
you. Thank you both. Urban v. Roman Catholic Archdiocese. Yes.
Good afternoon. I'm Phil Sempervivo, and I'm here on behalf of the appellant, Maris Brothers. And let me begin by indicating that the trial level court erred in several respects with respect to these legal files. And first, the files themselves are clearly all created in the anticipation of litigation. We submitted an affidavit from general counsel or outside general counsel explaining why they were created, the nature of them, and what was in them. And the court erred in the first instance by finding that this qualified privilege didn't matter because the record still could be obtained if plaintiff was able to show a substantial need for these documents and the hardship in obtaining them.
Allow me to stop you there. So Sister Kenny was the attorney for the Maris brothers for a protracted period of time, yes?
Yes.
Is it your position that all documents and all communications with Sister Kenny are fall under the attorney-client privilege?
If they are of a legal nature.
I beg
yes.
your pardon?
If they are of a legal nature and as they
Of
were
a
in this
legal nature, but prepared in anticipation of litigation?
Yes, absolutely, and
All of the documents.
all of the documents.
So in other words, any complaint that's forwarded to Sister Kenny, any documentation as to the nature of the complaint, that would all be protected?
If that communication is done for the purpose of legal advice, which in this case,
There were some documents or some notices of communication, requests for additional information. That's also prepared in anticipation of litigation or protected?
yes, because they were contemplating in certain situations whether insurance coverage would apply, reaching out to the broker.
And also coverage determinations?
Not the coverage determinations, because they're providing the information to the insurer's attorneys. And Your Honor, we know it in our brief, and we noted to the court below that it's clearly contemplated in the discussion on one of the pages, I think 100.
So wait, I'm sorry, you're stating that the communications regarding insurance as well as the coverage is also protected?
The information what they utilized in order to make a coverage determination here. But if there was, we don't have the insurer's internal files themselves.
But the information that not you, but your client provided to the insurer that was also shared with Sister Kenny, that would be protected under your.
Yes, absolutely, for two reasons. One, the anticipation of litigation, but also where is apparent from the documents, page 100, which I referenced before, the attorneys discussed it on both ends. They determined common interests applied. This is 20 years ago.
Explain something to me. And I'm going to use the image of a box. There's a box here on the bench, and all the communications concerning these complaints of these child abuse victims, they go into the box. If there's a document sent to the insurance company, it goes into the box. If there's any query from anybody, it goes to the box, and I give it to counsel. What is capable of being discovered? For me, it sounds like zero.
Your Honor, we
It sounds
disclosed-
like a big, fat, manufactured zero, counsel.
Your Honor, we disclosed
if I may
500
be so-
pages of that box.
Huh?
Well, using that box, we disclosed 500 pages of that box, which we believe that outside, if we were to look at this and not even call it a legal file, as even though they did call it a legal file, that they would otherwise be discoverable. And for that reason, we disclosed those 500 pages. The documents we held back were clearly attorney-client documents in several instances, work product in other instances, and other memos prepared in anticipation of litigation. Those are what we kept the privilege on. We gave a log. The court made a determination also, as I was indicating before, a determination that the qualified privilege could be, you'd still have to turn over the documents because there was a substantial need on the part of the plaintiffs for that information, and they'd be burdened. There's a burden to get that information, but there was never a showing.
Counsel,
The
can I
law's very
pivot
clear
to
that's
the list of alleged abusers? Why is that shielded from the plaintiffs to know impute the knowledge that the defendants had as to the alleged acts of sexual abuse at the school?
You're referring to the last point concerning the other abusers.
The list of the names of the abusers.
Well, this court has held, as we cited before, that the other abusers and the other victims, that information is properly redacted in such circumstances we had here.
The victims. the
I'm
names of
talking-
the victims.
I'm not talking about the victims, as my colleague just mentioned. I'm talking about the alleged abusers. Why isn't that provided as to imputing knowledge as one of the prima facie part of the plaintiff's case?
Because, Your Honor, it has no relevance at all to, in this case, Brother Damien.
So, counsel, I'm looking, there's a case named McNerney from 2023 where the names of the abusers had to be disclosed in order for there to be a query as to whether there was a patterned response to these CVA claims.
Your Honor, may I just take, I may have that case right?
Of course.
McNary v. Archdiocese of New York, 221 AD 3rd, 489. You can take a look at it and respond on rebuttal.
That'd be great, thank you, Your Honor.
Thank you. Yes.
Good afternoon, Your Honor. Jared Scotto on behalf of the plaintiff respondents. This court should not disturb either of the lower court's orders that are at issue in this appeal. Specifically, Justice Krause did not abuse her discretion in declining to vacate the August 11th, 2025 order, wherein she conducted a very thorough page-by-page and in often cases line-by-line analysis of the 500-page legal file that was produced for in-camera inspection.
But why the names of the victims?
The courts of this
Alleged
state,
victims or proven victims, either one.
one of the most prevalent issues in CVA cases, Justice Gonzalez, is notice, as Justice Hagler mentioned. Any of that information is not the Maris brothers or, in certain other cases, the Archdiocese privilege to assert. Those are witnesses to crimes. Those are people that may have relevant information. I believe with regards to additional survivors' names, we participated in a case, TB versus the Archdiocese of New York, wherein this court held that that information was relevant. Same thing with the JL case that was argued by my colleague, and we participated
I thought
in that as well.
TBV said that you could read that, you redacted the names of the victims. I thought that's what we said in TB.
Perhaps I misspoke, Judge, but I believe that in that case,
I mean, there's such a big distinction between the disclosure of the names of abusers and the disclosure of the names of victims, isn't there?
I understand your point, Your Honor. And with regards to the names of perpetrators, the courts of this state have held from Harmon to
The alleged
McNerney.
abusers, I think the cases have stated that that need not be redacted. But the case of in the instance of the the victims, the alleged victims, we stated that their names should be redacted.
Your Honor, I'm going to ask that other courts have held for that names of victims are relevant to the issue of notice. These are potential witnesses.
Counsel, so as my colleague just mentioned, look at TB. We just did it in 2025. I'll read it. The names of the victims of other alleged abusers within the organization may be properly redacted when disclosing personnel files and other materials relevant to the general handling of sex abuse complaints.
And that was with regards to IRCP documents, Judge?
That's regarding the request for the victims' names.
Right. And we also said the same in Maida. That's a second department case. And Harmon v. Diocese of Albany. That's a third department case.
The only reason
You stated that you need that in terms of notice. The mere fact that you have these complaints and that there are alleged victims, isn't that sufficient notice? Doesn't that sufficiently establish notice?
Well,
You actually need the names of the individuals. You know that they exist. You have the complaints. Why do you need their names?
Judge, we want as much information as possible in order to establish the pattern of what went on with
But they can
the
be called
organizations.
victim 1, victim 2, victim 3.
Exactly. That's
As
what I'm saying.
opposed to John so-on and
We know,
Peter so-on.
right, we know their existence. You don't need their names.
With regards to the defendant's other blanket claims of privilege, I'm going to pivot for a second. We believe that, just as you said, Your Honor, taking all of these documents, 502 pages, and putting them in a legal file and claiming that every single one is covered by attorney-client privilege, documents created in anticipation of litigation, and in certain interests, which is really a stretch and an overreach, would be the common interest provision. I want to draw the justice's attention to one particular claim on the privilege log, and that would be pages 101 to 107, which were ordered, turned over unredacted by Justice Krause. Justice Krause took a letter that's being written from Catalina Sugayan, who I've seen letters. She writes coverage opinions for insurance
She
carriers.
writes what?
Excuse me?
She writes coverage.
Coverage opinions and
Opinions.
yes,
Thank you.
for insurance carriers. And here, Justice Krause was very specific to say that that letter is relevant to the issue of notice. So I think that speaks to Justice Krause's careful analysis of the documents that were examined in camera. It shows that the position taken by the insurance carriers is most likely adverse to that of the Maris brothers if it deals with the issue of notice, because it speaks to the ongoing patterns, as we've discussed. Thank you very much.
Thank you.
Your Honor, I could not find the McNerney, but I did have TB. I was just referenced. And what I'd like to talk about the TB decision, it does state, while the names of victims of other alleged abusers within the organization may be properly redacted, while disclosing personnel files and other materials relevant to the general handling of sex abuse complaints, the identities of the victims allegedly harmed by the same abuser must be disclosed upon a plaintiff's request. So the decision in TB clearly makes the position that the victims' names can be redacted, but it does not speak as to saying that the abuser's name should be unredacted.
Discovery determinations are discretionary, right?
To some extent, as long as there's not abuse of discretion.
So Justice Krause is an experienced jurist. Generally, she's an experienced jurist with respect to CVA matters. She looked at all these materials in camera. Where is the abuse of discretion here?
Certainly, Your Honor. And counsel just mentioned that she must have done a careful review of the items, but there were several items that we discussed in our briefing where there were direct communications between Sister Bernadette Kenny and the Maris brothers, and those were still ordered to be disclosed. And those were not anything to do with putting in a box for an insurance company or anything. They were direct communications. They were also the attachments to those communications that were relevant to the communication that was being made. There was also a deposition summary from defense counsel in a pending litigation that was reported that with clearly work product, but that was ordered to be disclosed. There's a litany of things that we go through in our brief.
I mean, I saw that in terms of the depositions, but I have to agree with my colleague to some extent where it does not really bode well where you're claiming that every single document sent to Sister Kenny is privileged. Because then it's, as my colleague says, that what would be discoverable? It seems as if your position is that nothing is discoverable, and then talk about discretion and abuse of discretion. You really have to scrutinize the requests and your responses, where you're basically saying everything is privileged.
Well, normally I agree with Your Honor if that's what you're saying, but we didn't. We said half of, it was 1,000 pages, 500 of them we turned over, 400 and change we held back and provided a log. Sister Bernadette Kennedy was an outside counsel that was primarily working on legal matters such as these abuse claims. So communications with her, clearly, given the nature and the environment out there, lawsuits were being filed in other venues. You had letters coming from attorneys, and they concerned Brother Damien. There clearly was an anticipation of litigation on the documents that we've held back.
Thank you.
Thank you, Your Honor.
Weiner v. Realty Management.
Good afternoon, Your Honors. May it please the court, Hal Bierman and Greenberg Charg on behalf of the appellant. The sole issue on this appeal is whether landlords sufficiently stated veil-piercing claims against Joel Weiner, the principal of the tenant Weiner Realty Management, and Weiner Realty Management II, LLC, the successor entity of the tenant. This is a pre-discovery motion. The issue is not whether Weiner Realty breached a lease, it's whether Joel Weiner and Weiner Realty II abused the corporate form by transferring Weiner Realty's business to Weiner Realty II to evade landlord after accumulating millions of dollars in rent arrears.
How do you show that complete domination and control?
Sure. So Joel Weiner is the managing member or managing agent of Weiner Realty I, I'll call the tenant. Joel Weiner was the attention recipient for all notices sent to Weiner Realty. On February 22nd, less than a month after Supreme Court's hearing on Weiner Realty's Yellowstone motion, Joel Weiner registered Weiner Realty II with the New York Department of State and listed himself as the organizer.
And you're saying it was newly created?
Absolutely. On or about May 21st, 2024, Weiner Realty II, through Joel Weiner, signed a 10-year lease for the entire 12th floor at 2 Grand Central under the same trade name he was operating at the premises, Pinnacle. Old Pinnacle, same as the new Pinnacle. Upon information and belief, we said Joel Weiner signed that lease on behalf of Weiner Realty II. And then on or about July 17, 2024, less than 2 months after Supreme Court ordered Weiner Realty to post a bond of approximately $2 million for unpaid rent, Joel Weiner oversaw Weiner Realty's relocation from the premises to Grand Central. Weiner Realty II is carrying on the same exact business as Weiner Realty did.
Counsel, if I may. So we issued a case this year called Barini, and it said that sharing a common name and a common principle isn't enough to pierce a corporate veil. So how do you get around that?
So Barini is really about trying to go after the principle for signing the contract. That's not what we're doing here. This isn't about Weiner Realty. This is about Joel Weiner and Weiner Realty II causing Weiner Realty to breach the contract, vacate the premises in a blatant attempt to avoid its monetary obligation. Not only is it the same business, same trade name, same employees, same customers, same receivables, it's the same company.
So then are you arguing more so successor liability?
Really arguing alter ego. Alter ego, it is the same company, and Joel Weiner is the mastermind behind it, should be held responsible, especially at this early stage. We're just looking to amend the pleading so we can get real discovery and look at the undercapitalization. There is no way they moved from one location to another with the same business for any other reason, and they don't proffer any.
Well, you say for any other reason, but that's what I could not find. Where in your allegations is there any allegation that any of this was done in order to any way defraud you or cause injury to you?
I believe there's an allegation upon information and belief that it's undercapitalized, that Weiner Realty is now undercapitalized, because that would make the most sense. It's taking its entire business from one location to another under a slightly different name.
And that's not speculation, that because he formed another company, that somehow he took monies from the first company to form the second company?
Not when they're doing the same business, Your Honor. Not when they're operating as Pinnacle Realty. Not when they had the same customers, the same email addresses, the same everything. It's the same business. And they don't oppose that. They don't say it's not true. They don't come forward and say, you have to accept it as true at this early stage, but here's an affidavit saying we did this for a legitimate business purpose. We did this for some reason other than invading the landlord. Nothing like that exists in this record.
Thank you.
Thank you, Your Honor.
Good afternoon, Your Honors. May it please the court. Brian Shaw for the respondent. The hallmark of piercing the corporate veil is total dominion and control. As Justice Pitt Burke pointed out, there's nothing in the court question about what there's allegations about dominion and control by Joel Weiner over the respondent. And their answer was, he's the managing member. That's not total dominion and control. He is the attention recipient in the lease. Managing members do that. He registered as a member of Weiner Realty 2 as a member, not in his personal capacity. He signed the lease for Realtor Realty 2, again, as a member, not in his personal capacity. There's no allegations that Joel Weiner did anything other than operate as a managing member of these two different companies. There's no allegation of commingling of funds, no allegation of misusing the corporate form, of not adhering to corporate formalities. In fact, evidence in the record shows that corporate formalities were adhered to when there was a vote to sign the lease. This court has repeatedly held that the litigants claiming veil-piercing claims have a high bar, and they can't be pled by conclusory assertions made upon information and belief. The entire complaint's made, a proposed pleading is made upon information and belief. As Justice Gonzalez pointed out, the recent decision from January, Barini versus Informed Studios, where Justice Weber and Justice Higgett were on the bench. Cedar Capital Management versus Lilly. Justice Weber and Justice Gonzalez were on that bench from 2025. SM versus Madura from 2024, Justice Gonzalez again and Justice Pitt Burke, always holding that you have to have some facts. There can't be conclusions. To the extent that they say in conclusory fashion that the business, quote unquote, was transferred over, they don't point to a single asset. They don't point to a single specific instance or a fact.
Can they? Can they without discovery?
I think there are ways to do that, but again, even if they do, even if they have, it's not an allegation against Joel Weiner. It's a transfer of business from one to the other. That's either a successor liability, a violation of debtor-creditor law, which they haven't pleaded. There must be control, total dominion control by one party over the other. There's no allegation of control, total dominion and control by Joel Weiner. There's no allegation that Weiner Realty 2 was a parent corporation that completely dominated Weiner Realty. It was formed afterwards, and they're alleging there's some conclusory transfer. That's not sufficient for piercing the corporate veil. Maybe it is for another cause of action that they haven't pleaded, but for those reasons, the court properly held that the pleadings are insufficient here. Thank you.
Thank you.
Your Honors, in BPP 399 Park versus Pret 399 Park, this court found that a motion court erred to the extent it required showings, these detailed showings, this here is showing a fraud to pierce the corporate veil, and that the parent's decision that the tenant would stop paying rent and breach the lease constitutes wrongdoing sufficient to pierce the corporate veil. How do we know it was undercapitalized? Very simply. On December 4th, 2023, landlord served a default notice on Weiner Realty, seeking $2.2 million in arrears. December 18, 2023, the Weiner Realty brought a Yellowstone action saying it was ready, willing, and able to cure. On January 25th, oral argument was held on Weiner Realty's order to show cause. Less than a month later, Weiner Realty 2 is registered with the New York Department of State. After it sees the writing on the wall, never notifies the court. We don't need a Yellowstone anymore. We're no longer ready or willing to proceed with the lease. They then go ahead and 3 months later sign the lease under the trade name Pinnacle, under the same trade name. This is the quintessential, this is the pinnacle of piercing the corporate veil. For those reasons, Your Honor, if there's no more questions, we'll rest on our briefs.
Thank you.
Thank you.
Dusa v. Also Contracting. Yes.
May it please the court. Good afternoon, Your Honors. Brendan Fitzpatrick, counsel for the appellants. Your Honors, when the defendants are given the benefit of every inference, they raise issues of fact and credibility as to plaintiff's entitlement to summary judgment under Labor Law Section 240. And if I can, Your Honors, before Your Honors today, I'd like to focus on the issue of the availability of safe ladders. According to plaintiff, his version of the incident, he was given the top of an extension ladder that had been broken apart and separated, and he was given the top part, which had no feet for the bottom. And
So
that
it was a dismantled extension ladder.
Yes. He said he complained to Mr. Lawson about it. He said he complained to Mr. Serrano about it 4 to 5 times in the week or so before the incident. Said he complained on the day of the incident. And he said he asked numerous times for another ladder, and they said, if you complain anymore, you're going to get fired. So he's up on the ladder that day. He says it's unwitnessed. He falls. The ladder slips out from underneath him, and then he starts his 240 action. In opposition, Mr. Lawson, Mr. Serrano, and Mr. Rogosevich of L&L put in affidavits that contradict basically every item of his allegation. Mr. Serrano and Mr. Lawson denied that he ever complained about any having to use a ladder. They deny the fact that he was specifically given this ladder, which plaintiff testified he was given this ladder and could use none other. And critically, Mr. Lawson and Mr. Rogosevich attested that before the incident, as well as Mr. Rogosevich, who investigated the incident after it occurred, there were safe available ladders. And it critically, based upon this court's ruling in Perez, the ladders...
Serrano stated that they would not have given him that ladder?
Yes.
Because their ladders were aluminum, I think?
He said they were wood or aluminum, and the ladder that was in the photograph that plaintiff produced, they all said that wasn't one of L&L's ladders, and it looked like it was fiberglass.
Right.
They said that wasn't even theirs. But again, Mr. Rogosevich said afterwards, he looked at L&L's container, and there were safe ladders available.
So here, let's look at this from a different vantage point. You would agree that neither end of the extension ladder, the half of the extension ladder, had feet, right?
The ladder that, yes, the ladder that
It had no feet.
Yes, the ladder the plaintiff said he used had no feet.
Right, which is a problem, isn't it?
If there was no evidence to contradict the fact that there were safe available ladders on site, yes, that would be a huge problem.
It's a huge problem.
Yes.
And the ladder wasn't tied off. Isn't that another problem?
Well, 2 things on that. With respect to the availability of another ladder, and plaintiff places blame on the fact that wasn't given a safe ladder. He said this had no feet, and that was the reason that it slipped out from underneath him. But according to, again, Mr. Rogosevich and Mr. Lawson, there were safe ladders. And according to this court's decision that was affirmed by the Court of Appeals in Montgomery, the normal and logical response for plaintiff would have been to get one of those safe available ladders. Now, I understand that I'm not looking...
Was there anything in the record that the plaintiff knew of the availability of other ladders? And is that relevant?
He knew where ladders were located. He admitted, and L&L's ladders were located at one location at the GWB, in the L&L container. And that's critical, Your Honor, because in this court's decision, which plaintiff relied upon, the Perez case, which Justice Gonzalez and Justice Higgett, you were on that panel, the plaintiff in that case complained that he was given a scaffold that didn't have guardrails, and he complained about it. And the supervisors for his employer said, well, they're around, go look for some. And in opposition, he eventually fell and started a lawsuit. Now, in opposition to plaintiff's motion in that case, the defendants submitted the affidavits of 3 supervisors and 1 coworker. And they all testified, according to this court's decision, which was fairly detailed, that the evidence showed that it was fairly acknowledged that plaintiffs generally knew where these were. But even at argument, when this court pointed out that counsel couldn't identify where they were specifically located. Your Honor,
I'm sorry, and maybe if I missed you saying this, was there any instruction for him to use not that ladder that he used, but the other specific ladders?
Your Honor, from this court, there's conflicting case law as to whether they have to be specific.
Well, most recently in this year in Lopez, we actually made reference to the fact of as to whether or not the plaintiff had been instructed to use the other device as opposed to the one he chose.
Well,
so that's why I'm asking that question. Yes. Is there anything in the record that reflects that he was instructed to use not that, but this?
Your Honor, there's nothing specific, but in Perez, this court held that, actually specifically held that under 240, 240 does not attach when a safety device is readily available on site, and a defendant can show the readily availability of safety devices.
Right. I mean, yes, it could be readily available, but if the plaintiff doesn't know that it's readily available, then what does it matter? I mean, that's just my question.
Yeah, you have time on me, Bob.
Thank you, Your Honors.
May it please the court, Ephraim Wertenthal for the respondent. This is a classical Labor Law 240 case.
Is there any dispute that there were other ladders available on site?
Well,
there's no dispute that they were.
There is no evidence that at the time that the plaintiff received his ladder that there were other ladders on the site. There is no dispute because there's only their witnesses, Lawson and Roskovich, who claim to have gone at some point in time after the accident and said that there were other ladders, has absolutely nothing to do with the time that plaintiff actually took out the ladder and had his accident. That they came 5 hours later. They don't even say what time they came to the site to see how many ladders were there, or if there were safe ladders. They could have come 5 hours later. That has absolutely nothing to do with the time at 7:30 in the morning when plaintiff reported to work and took a ladder. Plaintiff said there were 10 L&L workers, there were 10 ladders, he got the bad ladder. There were no other ladders in the L&L container at that time. That is uncontradicted.
But L&L states that that was not one of their ladders.
Well, first of all, that's Mr. Serrano, the foreman. He didn't say that. He wasn't unequivocal about that. He said it appears. There's one photograph. He didn't say it for sure. He said the word, it appears to be a fiberglass, and we only had wood and aluminum ladders. But that's really not relevant to the topic because he got this at the site. He didn't bring this from his house. This is something that was given to him at the site. And it's uncontroverted. There is no testimony that at the time that when he received the ladder, that there were other ladders available, safe ladders available. Plaintiff's testimony was, when I got my ladder, when I reported for work that morning, this is the ladder that was given to me. This was the only ladder that was available.
Counsel, who gave him the ladder?
He got it from the L&L container.
He got it himself, or was he given it by Mr. Serrano?
I believe he came to the container.
Took it himself, or someone gave it to him?
I don't recall from the testimony, I believe he just took it himself. I don't think Serrano was there at the time. However, it's interesting to note, Serrano, who is the foreman, his foreman, who gave him the instructions that morning of what to do, submits an affidavit at page 761.1 of the record. Serrano doesn't say that there were other safe ladders. He's the one who would know better than anybody else from L&L whether other safe ladders or not. He doesn't say a word about that. He has an affidavit that's a little bit more than 2 pages, just consisting of 9 paragraphs. It's a bare bones statement. He does not say that there were other safe ladders. And he was the one who was there that morning. He was with
And in
plaintiff.
fact, he says in that affidavit that the employees were informed that they were not to begin work unless they had an assigned co-worker to hold or secure the ladder. Is that an adequate safety
No,
device?
of course not. This court has repeatedly held over and over and over again that as a coworker is not a safety device. Most recently in Melendez versus 1595 Broadway, McCarthy versus Turner, this court has repeatedly held that a coworker is not a safety device. And not only that, but as
Counsel, in looking at the record, I noticed that the Mr. D'Souza alleged that he complained repeatedly about the ladder, and that it was in fact the upper portion of an extension ladder that it was that was separated. So he alleges that he complained the week before to Foreman Serrano, but was told that he complained too much by Mr. Serrano and the shop steward. He also said he complained 4 days before to Mr. Lawson, who was the job superintendent for LLN. And later, Mr. Serrano, according to the plaintiff, said that he didn't have a choice. He had to use that separated ladder. What does that have to do with 241?
that has nothing to do with the date of the accident. Whatever happened before has absolutely nothing to do. That's just happens to be things that he testified to. The core issue is the date of the accident. When he reports to work that morning, what ladder was he given at the site? What ladder was available to him at the site? The uncontroverted testimony is that that was the only ladder available to him at that time in the morning when he reported to work. Not 5 hours later when Mr. Lawson or Mr. Roskovich, they don't even say what time they showed up, or not sometime earlier. At that time, when all the L&L workers had their ladders and all the ladders were taken out of the container, there's nothing left except for this bad ladder. This is a bad ladder on an unstable deck, which moves, which Mr. Andrew Siglio, the El Sol project manager, said this is a movable deck. You know, when workers walk on this deck, it moves. And plaintiff also said it would move because of the traffic
bridge.
on the bridge.
Yeah.
So this is a movable deck. It's a bad ladder. It's a bad deck. And like the motion court was precisely on target when it said there's no temporal specificity as to there being any other safe ladders at the relevant time. They don't have any evidence whatsoever of any available ladder at the relevant time. I don't care if there were safe ladders 5 hours later or 5 hours before.
Thank you.
Thank you.
Page 766, Mr. Lawson was attested that work began at 7:30 in the morning, and he said before the accident occurred at 9, there were safe ladders in the L&L container.
He said there were safe ladders?
Yes, he did, page 766 of the record. So not only before the accident, but after the accident, there were safe ladders. At page 769, Mr. Agosovich also said that was not an L&L ladder. They don't know where a plaintiff came from. And again, we're not looking for summary judgment to dismiss. We're saying that plaintiff's credibility has been placed at issue. And when we present evidence that there were safe ladders available and that plaintiff knew where the ladders were located, whether he
Counsel,
claims that he...
Can I stop you? Because I read that affidavit. I didn't see in the affidavit that prior to the accident that Mr. got his name? Mr. Lawson investigated and was there prior to the accident. He just gives a fact that the job site began at 7:30 and that the incident occurred at 9 a.m., but there's no nexus or connection where he says prior to the accident, I went into the room and saw there were available ladders. He just concludes that I personally observed there were available ladders that were readily and not accessible in the container. He doesn't say prior to the accident. Those words are for some reason omitted from the affidavit.
I think at page 765, he does say that there were ladders available before the accident.
Which paragraph, please? paragraphs 8 and 9 are the only time that he really talks about, pardon the pun, timing of when the ladders were there. I don't see a connection. I see that he avoids saying when he observed the ladders being in the container.
Your Honor, I believe that's the inference that we can be given.
So there's an inference. He didn't state that specifically.
No, Your Honor, the way I read it that there were ladders before and after the incident.
Should I read the paragraph to you?
Your Honor, that's fine. I
Okay.
trust your
Okay, thank you.
Thank you. Thank you both.
Thank you. Thank you.
Bronze v. XL Diamonds. Yes. Whenever you're ready.
Good afternoon, Your Honors. May it please the court. My name is Scott Doherty. I'm an associate attorney at the law offices of G. Oliver Coppell and Associates, and I'm appearing today on behalf of Plaintiff Appellate Yaniv Franz. This appeal stems from an order from the trial court which granted defendants cross motion for summary judgment, dismissing plaintiff's complaint, and denied plaintiff's motion for summary judgment on the issue of liability for his claim of discrimination under the New York City human rights law. We are asking the court.
Why didn't the defendants put forth a non-discriminatory legitimate reason for his termination?
So the allegedly non-discriminatory reason put forth by the defendants was that plaintiff traveled to Mexico. However, he only traveled to Mexico because he was explicitly forbidden from returning to work.
This is the craziest, I'm sorry. How you have someone who's test positive for COVID, who's told, by the doctors, you have, or by the health department in a letter, stay home for so many days. This is during the COVID epidemic, and he does that, and then he's told by his employer, come back when you test negative, and he tests positive and goes to Mexico knowing that he's positive, but he goes secretly. He doesn't tell anybody. He doesn't tell his employer. It's the busiest time of the year because it's Christmas season, right? And lo and behold, the employer tries to contact him and cannot, but recognizes by the dial tone, he says, that it's a foreign exchange. Because it sounds different when you call overseas. And he finds it and he says, oh yeah, I'm in Mexico. Why? Why is that discrimination? Why is it discriminatory to fire him? What does that have to do with COVID?
Because plaintiff attempted to come back to work earlier. He spoke to his...
He had tested positive for COVID, right?
Yeah, so yes.
So there's no attempt to go back to work when you test positive. He's not allowed to work, and as my colleague stated, there's a period of quarantine where he was not supposed to, go out, right? And certainly not go to work. So he couldn't go to work, but he could go to Mexico. I'm assuming the job was not in another country, right? It was here in the United States, right? Okay.
Yes.
So again, he couldn't go to work somewhere here in New York State, but he was able to go to Mexico. And how then, go ahead.
And there's evidence that there were other employees during this same time who also had COVID and they weren't terminated. So why is, again, how are we making the stretch that COVID was the discrimination, or his contracting COVID was the discrimination that he suffered, when there were other people similarly situated, not terminated? What was different here as to your client is that instead of communicating with his employer, he went on vacation.
So he did communicate with his employer on December 24th, 2021, during a phone conversation with his employer. He
Where
indicated
was
that
he when he had that communication?
It was December 24th.
No, not when. Where was he?
He was in Mexico.
He was in Mexico on vacation. Does this make any sense to you?
Yes, it does make sense. He only went to Mexico because he was specifically told that he could not come to work until he had a negative test.
I know, because, employers say, don't come to work because you have COVID. So that leads the employee to believe, but I can go on vacation. You have time on rebuttal.
Thank you, Your Honor.
May it please the court, Kevin Windles of Kaufman Dolowich for the respondents.
I guess on the other side of what we've already argued is the fact that he had not yet received a negative COVID test. So does it matter where he went? He couldn't come back to work.
Your Honor, simply put, he was not eligible for any vacation time, and he was supposed to be quarantining at home because he had COVID and because he was testing positive for COVID. It makes absolutely zero sense for him to get on a plane and go to Mexico while he was still testing
If he had went and quarantined in New Jersey, what's the difference?
The difference is it was during the work week.
The bridge traffic, I know, but what's...
COVID doesn't give,
GW. We have the other GW case.
And I don't mean to be flip about that, but simply put, he had no PTO time to take a vacation to Mexico. And he was supposed to be quarantining where he was, and quarantining means quarantining. It doesn't mean getting on a plane and going on a vacation being paid for by your employer. He was not even eligible for any paid time off at that point in time, but the employer did pay for his sick time. So he wasn't eligible for any away time, so to speak.
Well, and also he didn't receive permission, right? Nor did he didn't receive permission to travel.
No, he absolutely.
And he did not, he didn't inform his employer, your client, that he was going to be.
That's absolutely correct, Your Honor. He made no attempt to contact the employer about it beforehand. He never asked for permission, and it was simply a matter of they tracked him down, so to speak, when trying to find out how he was feeling.
Mr. Franz was an at-will employee, is that correct?
He was, Your Honor. He was. He was employed approximately 3 months at this job.
And the record indicates that the employers tried to reach him. They weren't able to, and then were concerned that something bad had happened to him because of COVID.
They did try to contact him on multiple occasions over a period of 2 days from December 23rd and December 24th. He had already traveled to Mexico on December 22nd. Same day, he received a positive test diagnosis.
But he got on a plane with all those passengers.
Yes, Your Honor. And so,
Thank you.
Thank you, Your Honor.
As Your Honors pointed out, what difference does it make whether he's quarantining in New Jersey?
No, I didn't say that.
Or Mexico?
I think my colleague said that. I think it makes a difference between New Jersey, no offense to New Jersey, and Mexico. But, so counsel,
They
where,
both got beaches.
Jersey, please. Anyhow, counsel, where in the record could we even come to a conclusion that COVID as a disability or his contracting COVID had anything to do with the dismissal?
Because plaintiff attempted to return to work on December 23rd. He specifically asked defendant Kimchi on December 20th if he could return to work on December 23rd. And the response was he could not because he had not yet tested negative for COVID.
Is it correct that there was a directive, a guidance that said that employers had to confirm that their employees were not contagious before returning to work? Or it's not had to, may. I think the terminology is may. And that was what from the, I got to figure out which commission it was. The Commission on Human Rights.
Yeah, so we're not saying that it was improper for the workplace to require him to produce a negative test, but rather it was wrong for the workplace to terminate him for not appearing to work until December 27th, which was the first day he could.
But in essence, what he was doing was he was using his sick time because, yes, he was in fact ill because of COVID. So he's using his sick time to go on vacation.
But only because he was explicitly told he could not return to work until he had a negative test. He wanted to come back to work and was told not to.
So your position is that it doesn't matter where he was. He could have been anywhere. But the fact that he was told not to return until that negative test, that's all that matters. Doesn't matter that any other impression that the employer might have had.
The reality is that plaintiff followed the direction of his employer. He adhered to what they asked of him. He didn't return to work until he had a negative test, yet they terminated him anyways. That's discriminatory. Thank you, Your Honors.
Foulas v. Hewitt, Weeks, Wasman. Yes.
Good afternoon. May it please the court, Louis Bottolato from Fortunato and Fortunato for the plaintiff appellants, the Foulas. Your Honor, the Niceprius court got almost everything right in a well-reasoned decision that correctly determined the other causes of action. But with regard to Labor Law 241, subsection 6, the court made two findings of law that were, we respectfully assert, incorrect. First, with regard to Industrial Code section 23-1.22b, which is a section that deals with ramps and runways, the court found that this particular accident location was not a ramp or a runway.
Was there anything in the record that talked about the structural integrity of this particular surface area that would lend itself to be constructed as a ramp or a runway, or was that just a generalization?
Your Honor, this particular object was called a trestle, and there was significant testimony on the record that established it was a runway, at least under the definition of OSHA that was accepted by this honorable court in the case D'Ambruso versus the Port Authority, which was affirmed by this honorable court 211 AD 3rd 573.
But we have the photographs, and the photographs and the description of the area is that it was an outdoor deck. It was a working area, and it was used. The decking was used to so that a crane could be operated there, right?
That's part of what it was used for, but there's actually...
So 23-1.22 talks about structural runways, ramps, and platforms for the use of persons, but this is a deck for the crane.
Your Honor, that's subsection A of 1.22, deals with persons, ramps for persons. Subsection B deals with ramps for motor trucks and construction equipment. And Your Honor, this particular item was described by their deponent as a, quote, a temporary elevated structure conducted underneath the existing bridge who, by driving pile, building superstructure on top, and placing crane maps built of 12-inch diameter timbers to provide access to the work site and to act as a work platform. That's 419 of the record. At 422 to 24 and 424 to 425, the deponent testified that the purpose of the New York trestle near Pier C is both a work platform and to provide access for personnel as well as equipment, including cranes. So under the definition of what a runway is for purposes of OSHA, which was adopted by this honorable court, as I pointed out in D'Ambruso, the definition of runway at OSHA regulation 1910.21 sub B is an elevated walking-working surface such as an elevated walkway. Now in this particular case, what we have here is an item that's elevated above the water by about a dozen feet on pilings that is then built with superstructure, which makes it even higher, then a 12-inch thick matting set down with railings on the side to keep workers from falling off. And it's obviously a walkway for both workers, as their deponent testified at those pages of record I mentioned, as well as a work platform and a means of moving equipment around.
So
And that's what
under
happened here.
1.22, you are going under 1, 2, or 3?
There's a 1.22 subsection B, and there are three.
B, 1, 2, or 3, yes. Which
I don't have it in my mind right now, I'm
Because
sorry.
3 applies to springing and deflection, right? That's not what happened here?
No, this is the requirement I'm going under was that the wood surfacing of this platform had to be of a certain number of inches thick, and at the accident location was a piece of plywood that was 3/4 of an inch thick.
So 1 then, okay.
Yeah, so that would be my argument with respect to 1.22. Now, the other determination that the Nissa Prius court made that we would respectfully disagree with is with respect to 23-1.7 subsection E, subsection 1. Now, as
We
my...
can deal with that on rebuttal.
Okay,
Yeah.
thank you.
Good afternoon, Your Honor. Ronald Doherty, Salmon, Chesisinger, and Turchi for all defendants, respondents. The court correctly determined, applying law, that these sections did not apply to this specific incident. And let me tell you why. 1, he's trying to say this is a ramp, runway, or some platform. They all have to be elevated under the regulation. That's why this was dismissed. You're creating a hazard that you could fall down on the deck. This is the deck that was not at issue. So those are excluded. Then if you look further, because you don't need to go outside of the regulations say stairways, ramps, or runways are a means of access to the work level, not the work level itself, which is this deck. That's why it doesn't apply. It doesn't apply because it's not an access point. Now, he cites from the record incorrectly that, well, people use it. Sure, you have to get to your workplace, but there would be no reason to have specific regulations then, because any workplace, you'd have to meet certain requirements. The deck, right? Why is the deck or the platform distinguished from a ramp? It's because a ramp and an elevated platform create a specific risk. And in fact, it cites it in there. The platforms are scaffolds, ladders, elevated platforms. You're above the ground. They're trying to prevent you from falling, not falling on the ground itself. That's why that's inapplicable. And the court correctly found this is not an elevated hazard and it should be dismissed. Secondly, the regulation he was trying to cite to related to passageways. This is important because a passageway also says in the regulation, it's defined as a walkway or passageway to access a point. Now, anything you need access. To get to the crane, you had to access the deck, but it's not the means to access the platforms. So for instance, the bridge and the other bridge, you didn't use this deck to access them. You used a crane to go over and remove materials. People didn't travel to get up to the bridge on this deck. This deck was only used for workmen that were there.
It was flat, right?
What?
It was flat.
It was flat, right. And it wasn't elevated above the ground. It was right on the
And what
water.
we're talking about is a little piece of wood that was covering a hole.
Correct.
And the plaintiff fell over. She tripped over the...
Well, the incident report and the general contractor says it gave way. Because what happens is you're driving in these pylons, you have holes, you sink this thing down, and you need to cover on
I stand
top.
corrected because I saw the picture.
Yeah.
And the picture shows the indentation.
So the problem with citing to that is also in the record at 116 and the contract, it says the construction workers give designated areas for travel. The whole platform was never, hey, do whatever you want to, go play on the crane. There were designated areas where this guy was not walking. So passageways and the regulations don't apply. So that's why these two regulations were properly dismissed, because the circumstances weren't met. And then finally, though, he's now saying and we indicate in our brief, he's now trying to say, well, under Section 200, you should have granted summary judgment for him. That's where we make the argument, no, the record shows there might have been a possibility of constructive notice, but not for these three defendants, the owner, a designer, and a contractor out of possession. Pearson, who was the employer of the employee, he had possession, but he didn't report any issue. He didn't report that there was a loose platform. He didn't report that there was a hazard. And the record is clear. This gave way. There's no indication whatsoever that there was a risk. And that's why summary judgment should have been properly granted under Section 200 also. Thank you.
Thank you.
First, with regard to his last point, he did not appeal this order. He is asking for this court to dismiss this case on a cause of action we did not appeal. We appealed 241-6, not 200. He's asking this court to grant him a non-appellant relief.
We're
So I
not
would ask
supposed to
you
do that,
disregard
right?
that. I'm sorry, I didn't hear you.
We're not supposed to do that.
Yeah. So getting back to the real point, with all due respect to my learned opponent, he just kind of made some stuff up as he went along there, in my opinion. I've never seen a case that said that a runway has to be only a means of walking. It can't be a means of also working. As a matter of fact, this court held just the opposite and also rejected his thing that it has to be at an angle. Now, as the picture showed, this is not directly on the water. It's elevated above the water. So it is an elevated platform. His argument about it not being elevated is kind of disingenuous. But getting back to the real point here, in Dembrusa, I'm going to read from the decision. Quote, plaintiff argues defendants violated Industrial Code 12 NYCRR section 23-1.22, which refers to structural runways, ramps, and platforms. ... I'm skipping a ways. Defendants argue this industrial code is inapplicable as the area where plaintiff was traversing was not an incline and therefore could not be a ramp. However, this court notes that OSHA describes a runway to mean an elevated walking working surface, close quote. That was one decision. Another decision in...
Which we will take a look at. Thank you both.
Okay, thank you, Your Honor.
Your Associates v. Cassim. Yes.
May it please the court, Mark Skolnick Law, representing defendant appellant Abraham Cassim. Your Honors, this appeal concerns the plain reading of RPL 231 and the finality of the court order by Judge Tsai in the Housing Court. In RPL 231, the legislator wrote void. The landlord then requested relief under 231 in the Housing Court to make the lease, in that case, void. He then succeeded in getting that relief in a trial by inquest. Subsequently, he requested in a plenary action for Your Honors the guarantees, relief against the guarantee, Mr. Cassim.
So let's cut to the chase.
Yes.
Chase. All right. So this is about a good guy guarantee, right?
Yes, a guarantee,
Okay.
yes.
And the good guy guarantee says, I waive all defenses at paragraph C, subsection 9, absolutely, unconditionally, and irrevocably waive all defenses and counterclaims. So with that said, why are you here today, given all of that?
Yes, Your Honor.
How can you defend against anything, given that very, very broad language?
So this was a motion for summary judgment filed by the landlord, and then a cross motion for summary judgment filed by us. The motion for summary judgment was granted. We argued that they could not only prove their own case, but that their case should be dismissed based on the voided lease. The lease was void. The guarantee...
Is it void or voidable?
It was void. So RPL clearly states that the lease would thereupon become void after a finding. Here there was a finding in the Housing Court by Judge Tsai, and then the trial court determined after, erroneously, that it was avoidable.
Do we not have, is there case law out there interpreting this particular language to, in fact, mean voidable?
I mean, the statute says void. I can read the statute.
We know the statute.
I don't think I need to, but...
Have we not stated that it's voidable?
Because if it's void, that's void from its inception. Why would that apply here?
Because the plain reading of the statute says it's void, and Judge
Here you
Tsai
have an
also
illegal
says it's void.
use. You have a letter from the DA saying you have to evict your tenants because of the illegal use. And in this case, it would be the, am I right, the subtenant? But at any rate, you have to, instead of being a convenience store, it was the Bing Bong candy shop selling marijuana, hemp, and I guess cannabis-related items without a license. So doesn't the law protect the landlord under these circumstances by saying the lease is not void, it's voidable, therefore you can recoup rent arrears?
No, Your
And thus trigger the guarantee that's unconditional, absolute, and irrevocable.
No, Your Honor, because the landlord chose to use the illegal use holdover language and apply to
Chose
31. Yes,
or was
correct.
was
They chose.
directed by the DA?
Well, they chose to. They could have filed a traditional holdover case saying there was a violation of the lease.
How could they have done that? They were directed by the DA to, that there was an illegal business being conducted there.
Well, they were directed to evict the tenant. And in a traditional holdover, you can evict the tenant by serving a notice to cure and a notice of termination. I don't think that I could argue that the tenant was in violation of the lease.
There's no cure here.
Right.
There was no, they couldn't serve a notice to cure in light of what.
What would the cure be?
To cease
At this
unlicensed
point in time, they
activity.
had already violated the law.
To cease violating law and conducting any
They had
unlicensed
already done.
activity.
So cease violating the law?
Correct. And so using 231 and applying that statute and filing that type of petition, it gives you something by not having to do those predicate notices. It expedites relief, which is what happened here, and them regaining possession of the premises, and was why the statute was written that way. But it does still void the lease. And
With respect to the language of 231, isn't the language that if the tenant or party in possession engages in illegal conduct, that the lease shall thereupon become void? Not at that moment becomes void. Not that it's void ab initio, which we now treat as a nullity, but thereupon become void.
well, thereupon it becomes void, but it certainly doesn't make it voidable, and it does, under the plain reading of void, make it a legal nullity. That is what void means. I don't see any,
From that moment on.
yes, but as if the lease never existed.
That's so convenient.
Yeah, that would work really well. You have time on rebuttal.
Thank you, Your Honor.
Good afternoon. My name is Mark Friedlander. I am here representing the respondent and the landlord. If I may be, to use your expression, to cut to the chase, this court has focused on what this issue is, okay? And if I can at the moment, all right, Justice Leibovitz, in footnote number 1 on his decision, he said, courts in dicta have dismissed the notion that a tenant could unilaterally absolve themselves of a lease obligation by committing illegal acts, okay? And he cites to an appellate term First Department case in 1969, which is 220 West 42 Associates versus Cohen, okay? I'm at a loss to understand why my adversary keeps insisting that the lease was void ab initio. This court has recognized by the inquiry made of my colleague, focused properly, in my opinion, the fact that the word void as used in the statute has a history of meaning void at the option of the landlord, okay?
Well, in defense to your friend here, in 231, if the legislature wanted to say voidable, wouldn't they simply have said voidable, shall thereupon become voidable? Wouldn't that have been the clear and unambiguous way to express it?
Perhaps, but the case law that has evolved both before and after 230 or RPL 231-1 has made it abundantly clear that the word void does not mean void ab initio. As a matter of fact, Justice Leibovitz, in his decision, all right, he purposely calls attention to the fact that the word void was used to eliminate the need for a landlord to serve a notice of termination. All right? And he refers to the case of New York Housing Authority versus Harvell, which is an appellate term First Department case from 2001, which is 189 miscellaneous second 295. Right? Again, you know, the thing that's particularly peculiar to me is there is not any effort made by the appellant to show an issue of fact.
To show,
An issue, I'm sorry, an issue of fact, okay? We
So
have,
regardless of whether it's void or voidable, does that mean that the guarantor is not liable, given the terms of the guarantee?
well, the guarantee speaks for itself, okay? I mean, just as, forgive me, I'm blanking names today. It's my age. I can't hold on to this. I'm sorry?
Gonzalez.
I'm sorry, Your Honor. Made the point that the guarantee is on its face, it's totally enforceable. There is no defense to the guarantee. I mean, when you have an action on a guarantee, putting aside the issue with regard to void or voidable,
Right, that's
the
what I said.
guarantee, all you have to show is the guarantee was signed, okay, that the tenant did not perform, and the obligations on the guarantee ripen, and then the guarantor failed to do what he was supposed to do on the guarantee.
Because there are no defenses. So there are no defenses, regardless of why the tenant did not perform.
That's correct.
And in this instance, the argument is that the tenant did not perform was because they were evicted because they were engaged in illegal activity.
That's true. And at risk of gilding the lily, if I may a moment, if you look at the cases that my adversary relies upon, when he talks about the lease being void ab initio, those leases were either voided, for lack of a better word, by operation of law, or they were illegal contracts.
There was one, I think there was a zoning issue. when
There was
they
one.
changed
There was
the,
one. There was one was a zoning issue with regard to a movie theater. There's
Right.
another one regarding the 18th Amendment during Prohibition, where there was a saloon, and they said, "Listen, the saloon's out of business. The lease is a nullity." All right, and also it's very interesting. He makes reference to a decision in by Justice Branston in 1165 Broadway Corp. Versus Diane, New York Sportswear, Inc. That case expanded the use of RPPL Section 231.1 to include, pirated sportswear and clothing, which at that time no one had used the law in that context. In that case, there is no discussion of void, voidable, or that the lease being void ab initio. All right, and but again, that case for some reason made its way into the brief in support of this argument. There's an issue that I think, one last thing I want to state. He tries to say that it's collateral estoppel. Okay, there is no collateral estoppel on the part of this appellant with regard to the decision in front of
Thank you.
Justice Leibovitz. If I just may, there is.
That was it, but thank you so much.
Okay, thank you, Your Honor.
Appreciate it.
Very briefly, Your Honors.
So counsel, I had a question. Even if we set aside the broad language of the guarantee, what standing would you have to assert tenant's defense even without the guarantee? You're not the tenant, so how would you be able to even assert that?
Because the guarantee obligates the guarantee obligates Mr. Cassim to whatever the lease held the tenants to, and because the lease was void.
No, the guarantee says you're obligated to pay whatever is due under the lease.
And the lease was
and says
voided.
specifically that you cannot assert any defenses, and also it says that you wouldn't have any standing even to assert it.
But to the extent that there's no obligation to pay anything under the lease because it's been voided, then Mr.
Then that would be a defense by the tenant, not by you, right?
Well, if Mr. Cassim is a surety, the appellant's a surety of the tenant under the obligations of the lease. So when there's no obligation to the lease by the tenant, Mr. Cassim would no longer have any obligations.
If the lease is void ab initio, there can't, as a matter of law, there can't be rent because there's no lease.
Correct. And
Is that
Mr.
the point?
Leibovitz, and very briefly before I finish, Judge Leibovitz, Justice Leibovitz, noted in subsection, or the footnote number 2 of his decision that they could still pursue the guarantor under use and occupancy claims as well as use and occupancy claims against the tenant, just not the contracts claims. So it doesn't make it so that it's impossible for them to collect either. So these arguments of fairness to public policy, which were also in counsel's brief, shouldn't be persuasive.
Thank you both. Kingdom Associates, BWBC Services. Yes.
I think Judge Weber left.
Oh, you definitely have to speak into the mic.
I'm sorry, Judge Weber.
No, you're fine.
Okay,
Go
all right.
ahead.
All right, great, thank you. Good afternoon, Your Honors. My name is Parshram Razir. I represent the plaintiff.
Microphone up.
I represent the plaintiff appellant, Kingdom Associates. Kingdom's complaint was dismissed on a pre-answer motion to dismiss pursuant to CPLR 3211A1 and A7. It's our contention that the judge's ruling was erroneous in 4 aspects. First, the order was erroneous because the lower court completely ignored the fact that Kingdom had worked for 30 days at the project before it was terminated. They were never told by WBC, the respondent, that they weren't permitted to work at the project, nor did WBC inform them that there was any objection to the work. They basically allowed.
This is a 3211 motion. This was a, right?
This was a yes.
The motion to dismiss was for under 3211,
Yes, Your Honor.
right? And so, as plaintiff, yours obligation is just to plead, make certain pleadings, right? How did you meet that? Because we're not really talking about the issues of fact that might come later, as the trial court maybe alluded to. We're talking about the pleading stage.
Well, there are 2 situations. Just to, if I could get some clarification, are you referring to 3211A1 or 3211A7? Because it's our contention that there really is no dispute, that we failed to state the element.
Well, the sufficiency of the pleadings would go to, I guess, A7, and under A1, the documentary evidence as to whether or not they utterly refuted that. But why don't we deal with A7?
A7? Yeah, Your Honor, for breach of contract, we've alleged the 4 elements: that there was a contract, it was breached, that we fully performed our obligations, and we suffered damages as a consequence. For unjust enrichment, forgive me, Your Honor, I don't have it off the top.
Well, it was unjust enrichment and quantum merit, right? And so the issue here is whether or not, was there a written contract?
It's our contention that there was a contract, the proposal, which we performed. There was an agreement as to scope of
It
work.
wasn't a signed contract, though.
Wasn't a signed contract, but it's not necessary that the contract be signed. So, and I refer to the, I believe, the Jackson case, which is almost on point with this case, where there was an agreement as to scope of work, there was an agreement as to price. The work was performed by the subcontractor pursuant to the terms of that particular subcontract, but it wasn't signed by either side.
So if we go down that path on the breach of contract claim, do then the other causes of action become duplicative?
Well, because did you say, I'm sorry, I didn't catch.
The other causes of action, quantum merit, was it unjust enrichment? Am I looking at the right one?
Yes.
Promissory estoppel? Do they?
Promissory estoppel, right? Those were the other 3. Do they become duplicative if we're saying that there's an actual contract?
Well, no, Your Honor, because the WBC, the respondent, is disputing the existence of our subcontract. And since there is a dispute as to the existence of our contract, and the Court of Appeals has ruled on this already.
Can I ask you about unjust enrichment? What did the defendant get enriched by? What did you provide to the defendant that enriched the defendant? Did you plead that?
Yeah, the defendant was enriched by the fact that he received materials.
You plead, in your complaint, you say that you gave X amount of materials on the job for the defendant. I thought that you never even you never even had 1 foot on the project.
Well, Your Honor, that should not even be considered by the court.
Let's assume not, but where did you in your complaint plead that you provided certain materials to the defendant? I didn't see it.
We don't do it as specifically as you have stated, but the elements for unjust enrichment permit me to plead, well, the pleading of causes of action in New York are require generality, not that they be done specifically. But you are correct that we do not specifically state in the complaint that the benefit that was conferred on the defendant under unjust enrichment was X, Y, and Z. However, Your Honor, we do have our mechanics lien that's attached to our complaint, and in that mechanics lien, we state what type of services we provided at the project directly to WBC and the owner. So,
You have time on rebuttal. Thank you.
thank you, Your Honor. Thank you.
Good afternoon, Your Honors, and may it please the Court. Pooja Sharma from Littler Mendelsohn, representing defendant respondent WB Services, Inc. If I may respond to some of the comments made by opposing counsel. For example, he's claiming that there was no signed contract. We agree with that, but he's claiming that it didn't need to be signed under the Jackson case, which he claims is completely on point with this matter. It is not on point with this matter. And second of all, it's waived, and it should not be before this court for two different reasons. This argument was not made before the lower court, so it was not preserved for this appeal, and it wasn't made in the opening brief of this appeal.
Did the trial court maybe err in applying the wrong standard here? I mean, we're at the plead-in stage, and from a reading of the lower court's decision, one might think that it was a summary judgment motion.
No, Your Honor, the lower court's decision mentions a few times that it's a motion to dismiss, motion to dismiss, motion to dismiss. Only at the very end does it have a little typo where it says motion for summary judgment. But if you look at the court's decision, which is page 4 and 5 of the record, specifically on page 5 of the record, it says, here WBC has presented documentary evidence which plaintiff has failed to rebut that plaintiff was asked to bid on the underlying project. Plaintiff did bid on the underlying project and was informed in no uncertain terms that ownership has not selected, released, and or authorized WBC to enter into a contract agreement. So there, it's clear that the court is looking at the documentary evidence and agreeing that it refutes the claims made in the complaint. At that point, I mean, it's intuitive to me that a plaintiff receiving this documentary—
A contract can exist without actual signing, right?
That is what the Jackson case says, but that was not the case here. Again, that argument is not properly before the court because it was waived under two bases. But the Jackson case is distinguishable because, first of all, that applied to a workers' comp claim. This is not a workers' comp issue. Secondly, the two parties in that case had a prior course of dealing. The contractor regularly used that subcontractor for roofing work, and because they regularly worked together, they used the same contract in every transaction. So the court was able—
Why can't this be an oral agreement?
I'm sorry?
Why can't this serve as an oral agreement rather than a written agreement?
The parties never came to a meeting of a mind. The material terms were not set forth.
This is a 3211 motion. They argued that there was an oral agreement.
The documentary evidence which was submitted, because this is also based on documentary evidence, not solely failure to state a claim, definitively shows that there was no meeting of the minds. They
Well,
hadn't—
the proposal, the revised proposal states agreed to and accepted. So why is that not, why would that not constitute a meeting of the minds?
It was not agreed to and accepted. We did not, WBC did not sign where it said agreed to and accepted, and it requested only a revised proposal from Kingdom. It never said, we are agreeing to this. It never issued a notice to proceed, notice to start, and none of this was disputed in the opposing papers.
Remember that on a 3211 motion, it has to be conclusive. And here, there's a pleading stating that while you disagree, that they believe there was a meeting of the mind and there was a formed oral agreement.
Again, Your Honor, we are also have to review the documentary evidence that we were allowed to submit because it's based—
How is that conclusive?
Because the email exchange show that it was solely a bid. He only requested a revised proposal. He didn't say, okay, we have a deal, or okay, we're awarding you the contract. There's nothing in the—
They proceeded to perform.
They didn't notify WBC that they were performing. He claims that they did, but the first time WBC received notice that they had done any supposed work was on August 16th when he said, we've obtained these insurance certificates, and immediately thereafter, like in 15 minutes.
So counsel, I don't understand something. There was work done by Kingdom between July 11th and August 21st of 2024. So that's over a month, right? Was there ever any correspondence from the defendant, from WBC, saying, stop, what are you doing? How come you're on our property? How come you're doing work? What, is there anything like that, as in saying, we don't have an agreement, go away, get off, get away, go?
2 points. One, they never performed work on the premises, so we had no idea that this was going on.
I'm sorry, what did you say?
Yeah, what did you say?
I didn't hear you.
Kingdom did not perform work on the project site. Materials were not delivered to the project site from Kingdom. They did not step foot on this
They
project.
say that they did.
No.
They say that they delivered materials and performed services at the project site.
They did not. And if you go to the invoices in the record, they actually show that that didn't happen. These invoices that supposedly is for work Kingdom did, all of these are for third-party companies billing it to Kingdom. There's no indication that Kingdom forwarded these invoices to WBC, or that WBC was aware that any of this happened.
We need discovery here, then.
Yeah, because we have the allegation, the complaint, there are allegations in the complaint that they did in fact deliver materials to the work site and that they performed labor, I think it says, at the work site.
That's not reflected in the invoices. Their complaint also references that they did work, and these are the invoices that came from the plaintiff. And none of these invoices show that any of this work was ever delivered. First of all, this is for like insurance. It's for shipping some rebar pipes. Like on page 51 of the record, it shows shipped to Kingdom Associates. It never shows shipped to the project site, which was in Broadway in Manhattan.
Thank you.
Thank you.
Regarding whether or not we delivered the material that was on site, the mechanics lien is our prima facie evidence that we did.
Was that included in the record?
Yes, it's in the complaint. It's attached to my complaint.
Okay.
What was the page number again, you said?
Just bear with me 1 second, please.
Thank you.
You said it's attached to the complaint?
Yeah, it's on the record, page 90.
Thank you.
And what it says that the labor performed and the material and equipment furnished was that necessary to provide the pipes, threaded, hollow bars, etc. So we do state in our pleadings that we did provide the services to WBC. And this is a requirement under the lien law that you just can't lien for not providing labor. The materials have to be provided pursuant to the lien law at the project site. And I just want to go back to the courts.
Thank you. Thank you both.
All right, thank you, Your Honor.
Okay. People v. Christopher Santana.
Apologies.
Yes.
Good afternoon, Mary Catherine Smith from the Legal Aid Society, representing Mr. Santana. Despite finding that Mr. Santana was subject to custodial interrogation when questioned by his parole officer, the hearing court below denied the motion to suppress.
The initial search, because I think we need to break this up, and we can't just talk about custodial interrogation on this macro level. The initial entry to go into the apartment, that was part of a safety search, right? As his duties as a parole officer.
Yes, Your Honor. Counsel below.
And then there was ammunition that was found during that search.
Yes, Your Honor.
At that point, up to that point, we're just dealing with that, was Miranda required under our case law?
At that point, under our case law,
it wouldn't be required, right?
Right.
But then we have another question that comes after that, after we've just found this ammunition, and the question is, where's the gun? What do we do about that?
Yes, so that question of where's the gun is where the interrogation, the custodial interrogation happens. Mr. Santana is sitting in a chair, he's handcuffed, half dressed.
But he was handcuffed as part of the safety search, not in relation to custody.
Your point's well taken. He was handcuffed in relation to the search because they knew they were searching for a gun in the apartment. But he is handcuffed, he's blocked from leaving the apartment, he's not free to leave, and that is the definition of custody. When this question, for which there's a culpable answer, is asked, where's the gun, based on the finding of the ammunition. And so the case law on parole officers, which admittedly the hearing court as well as defense counsel below at the hearing were not familiar with, is that Miranda does apply to parole officers in the specific scenario where where it is a custodial interrogation, such as.
Well, I mean, the Parker and the English cases are a little bit different, right? Because those parolees were going into the office, they were being questioned about specific crimes. That's a little bit different than what happened here. And then my next question would be, even if we were to agree that that particular question, where's the gun, might have been the subject of questionable custody, but maybe interrogation, the statements that were given later on, why aren't they sufficiently attenuated from whatever else happened?
Your Honor, on appeal, I would concede that they are sufficiently attenuated. What we're really seeking here is the suppression of the direct fruit of the statement, which is Mr. Santana saying there's a gun inside of the jacket on the bed. And
why is, okay, so let's deal with that statement then. And inside this home, there were other individuals? Children. And why wasn't there an exigency at that point to find out where's the gun that goes with this ammunition?
Your Honor, there wasn't an exigency because the parole officer was already conducting a thorough search of the home. She was looking for a gun. That's what the tip was about. Some of the cases with exigency have more pressing facts.
Why would there still not be exigency where the tip was that he had a gun? They go in, they find the ammunition, but they don't find the accompanying gun. So why is the exigency not still viable?
I think that it's not enough facts. So if we look at the cases where courts have found exigency.
So normally where you have a tip that there's a gun, and then you find ammunition, that may lead you to believe that there's a gun somewhere in this apartment where you have individuals, including children.
If I may briefly answer.
Please.
In some of the cases where there has been exigency, there was domestic violence, there was the defendant being alone, getting undressed, potentially having access to a weapon, as well as a fear of executing an arrest warrant, taking the defendant from the premises and leaving a gun. Thank you.
Good afternoon, Emily Aldridge for the People. At the outset, this was a valid waiver of appeal, which precludes.
Well, let's move beyond the waiver, because I just really want to follow up on these questions that we've been asking. Where's the exigency when the defendant at that point had been handcuffed?
Well, as Your Honor indicated, he was handcuffed because of the safety search. There are cases, as I said in the brief, where they look at, even when he's handcuffed, this was a defendant with a violent felony history. There were children in the apartment. While this court's decisions are generally concise without significant degree of background, this case is very similar to the Federal Jones case that I cited in terms of finding the ammunition and the children and the concerns there. Now, as counsel just indicated, this, and it's.
I don't know if, counsel ended on one of the exigent factors in other cases being that the possibility of leaving this gun in the house.
Yes,
so,
and as.
I don't know if they meant to end there, but that's where it ended.
Well, as counsel indicated in the opening brief, he could have been violated just on the ammunition. And then as counsel says in the reply, they're not going to leave the ammunition right there. So that begs the question, what are they going to do? So they're searching that room. and they find the ammunition, and then here's the ammo, where's the gun? It's on the next bed. As defendant said in his later attenuated statement, that Officer Garrett said, we can tear up the room. And so we could have kept looking. This certainly was not.
I'm sorry, that begs the question as to why you don't, at that point in time, you don't Mirandize him. I'm not understanding. Why couldn't you Mirandize him at that point in time after the?
There was no need to Miranda, again, under the safety exception, which this, not only the Jones case, but, for example, as we cite in the brief.
So you're arguing that the exigency continued?
Absolutely. But as we say in the brief, the purpose of suppression is deterrence. Here, this was not a flagrant violation. She waited until she found the ammunition before asking anything about the gun. There's no questions about where did you get the gun. None of those questions. This was a parole officer doing her parole duty about an active violation of parole and a safety risk. She certainly could have searched the room without asking any questions, but she sought to limit the search and expedite the search to defendant's benefit and was not motivated by any bad faith or nefarious purpose. And if there are no further questions, we ask that you affirm.
Thank you.
Thank you.
Would your honors like me to address the appeal waiver or return to the public safety?
Whatever you.
I would just like to make one more point about public safety, being that in Jones, the court specifically said that Jones, upon being arrested, might leave uncontrolled at the scene a weapon. Here we were at the beginning of the search, and the shortcut of bypassing Miranda to find the weapon faster was not justified by exigency. As to the appeal waiver, we argue this in our briefs, but I would just like to state that the language of finality, the court telling Mr. Santana that he would waive the right to appeal any legal issues connected with his case, any plea, or any legal issues connected with his case, pleas, or sentence, was language of finality that was contradicted by the written waiver of appeal, which calls into question how informative that written waiver could have been for Mr. Santana. If you have no further questions, thank you.
Thank you both. Last case for argument is the will of George S. Kaufman.
May I proceed?
Yes, please.
Good afternoon. May it please the court. Frank T. Santoro, Farrell Fritz PC, for the appellant Thomas Kearns. The question on this appeal is whether the Surrogates Court correctly applied the good cause standard under Surrogates Court Procedure Act, Section 1410. Mr. Kearns was replaced as the nominated fiduciary of the decedent's trust and of the decedent's estate by 2017 instruments that were executed just a few months before the decedent's death. He has no beneficial interest in the estate under the prior estate plan or under the 2017 instruments. So that means that he does not have the right to conduct SCPA 1404 discovery or to challenge the 2017 instruments absent a showing of good cause under the Surrogates Court Procedure Act, under that section 1410. So what do we—
Marshal for us, by your lights, what that showing of good cause was here?
Sure. Well, starting with the legal standard, we have to look to the authority, what the courts tell us, the appellate authority, and actually what this court told us in matter of Torshner. And in matter of Torshner, the court articulated the standard, which is whether the displaced fiduciary can demonstrate a sufficient factual predicate to warrant discovery, that there may be a problem with the 2017 instruments in this case. It doesn't require a showing by the displaced fiduciary that the instruments are invalid as a matter of law, that there's no issue of fact. It doesn't require a clear and convincing evidence showing. It doesn't even require a preponderance of the evidence showing.
But what did Mr. Kearns show?
Mr. Kearns demonstrated, without the benefit of discovery, he came forward with that sufficient factual predicate. The 2017 instruments were created during the pendency of a mental hygiene law Article 81 proceeding.
Counsel, if I could just stop right there. Does it matter that the only thing that Mr. Kearns can recover here would be statutory commissions? Would that change with any amount of discovery, and is that relevant to your position?
No, that SCPA 1410 exists for that purpose, right? A displaced fiduciary has no beneficial interest in the estate, so that's why the displaced fiduciary must show good cause.
Right, but how do you continue?
So
What's the good cause? There's three of us now who are asking the same thing.
there's three things. These instruments were created during the pendency of an Article 81 proceeding where a Supreme Court justice, presented with evidence, appointed a temporary guardian for the purposes of protecting the decedent, and appointed a court evaluator. Both of those, and the record is replete with their statements, both of those court appointees, nothing to gain or lose, completely independent witnesses, were unequivocal based on their interactions and observations of the decedent.
Right, but let's compare what Mr. Siegfried said in his affirmation and Mr. Barbuti said, Mr. Siegfried being the temporary guardian and Mr. Barbuti being the court evaluator. Let's contrast that with what Dr. Petito said, which is that he saw the decedent in 2017, September. He was aware, engaged, conversational, quite charming, suffered from memory loss, but nonetheless understands important issues in his life at a macro level, can articulate his intent and preferences relative to those issues, and so on. Is able to make high-level decisions.
Was there ever an appointment of a guardian?
There was an appointment of a temporary guardian, not of a permanent
I mean,
guardian.
the guardianship proceed, I guess my question is, it was never concluded. There was
It was not. He died before it could be concluded.
But would you contrast the findings, I'm going to call them findings or observations, of those two sets of people?
Sure. Well, at that point, you're weighing evidence, weighing attestations and affirmations of witnesses. And the issue here is whether we have a right to conduct discovery,
Right,
not
but does that
not weighing
establish good
credibility.
cause for Mr. Carnes?
Mr. Kearns, in combination with the other factors, I believe it does. These two independent witnesses, we have the fact that the court-appointed counsel himself urged the surrogates court after the decedent died not to become the instrument for the protections of wrongdoers. He was constrained by attorney-client privilege and by work product privilege.
May I? And to the extent that that the only change that was affected by the 2017 amendments was a change as to how the fiduciary, is that the right, would be paid?
There was two changes: the identity of the fiduciary,
The identity and then
the removal of the cap on commissions.
Right, no more cap.
And I think it's important to emphasize here that the change in fiduciaries is substantial because the bounty of the decedent's estate goes to charity, a broad, general charitable foundation that gives substantial discretion to the fiduciaries as to who should receive that bounty. Who do you choose to do that? People that you've known for a long time, for 20-plus years.
Thank you.
People that are your friends. Thank you, Judge.
May it please the court, my name is Zachary Newman from Thompson Coburn, appearing today on behalf of the respondent, Bessemer Trust Company. Your Honors, the surrogate fulfilled its gatekeeping and exercised sound discretion under SCPA 1410 and 1404 to deny Mr. Kearns a displaced fiduciary's speculative, self-interested attempt to litigate over fiduciary appointments.
But why isn't there good cause shown when the temporary guardian and the court evaluator, I believe, set forth certain affidavits indicating that maybe there was some sort of cognitive deficiency or undue influence?
Yes, Your Honor. So there is no good cause with respect to the submissions by Mr. Siegfried or Mr. Barbuti or even Mr. Meyerowitz. And the surrogate who throughout the transcript and throughout the decision demonstrated
Can
that
you add Ms. Harper too?
and Ms. Harper as well, who is a litigant in the Article 81 guardianship proceeding. The surrogate gave no consideration, or reviewed them, but gave no consideration when determining whether good cause was met by Mr. Kearns. Why is that, and why was that the right decision? It was the right decision because, first of all, 1410 puts a hurdle in front of Mr. Kearns, a displaced fiduciary, who was removed, not according to speculation. We know why he was removed, because unlike in any of the other cases, you have in the will codicil and in the trust amendment, the statements by Mr. Kaufman that he lost faith in his counsel, and that because Mr. Kearns started the guardianship proceeding, he's lost faith and he's removing him.
Just go to good cause. 1410 says that if there's good cause, even if there is an issue with the fiduciary who's seeking commissions, they can overcome that hurdle, as you said. Why isn't, as my colleagues just mentioned, Ms. Harper, who knew the decedent for over 20 years, we have the Mr. Siegfried, who was the, I believe, the temporary guardian, Mr. Barbuti, and then at least 3 affiants stating that he lacked capacity and that the decedent was being taken advantage of. There was undue influence, that's the words that was used. Why isn't that enough to at least on this record, to go over that hurdle, meet the hurdle?
First of all, I would respectfully submit that you can't go over the hurdle until the displaced fiduciary demonstrates that his intentions are motivated by either achieving the testator's wishes, that it's not solely motivated by commissions. So with all due respect, I don't believe, and according to the Lerman case in the 2nd Department, the Carey case in the 4th Department, you can get over that hurdle. But I want to answer the question as to why it's not good cause. Let's say there is no hurdle. You have a submission by 3 individuals who were working with Mr. Kearns throughout the guardianship proceeding that don't speak to what Mr. Kaufman's capacity was in December of 2017 as to whether he had the capacity, the testamentary capacity, to just remove his fiduciary, okay? That is a different level of capacity than signing contracts or preparing a new will. But that notwithstanding, you have 3 individuals who are not doctors, and their affidavits simply have no persuasive power, and their lay observations are just not sufficient.
So
But that's not all the record has.
That's why I was asking your friend to contrast the observations of those persons with Dr. Petito, who saw the decedent in 2017, who had been the decedent's doctor since 2013, and he said he's okay. He's not 100%, but he's okay. He's competent.
And you have his spouse who's submitting affidavit testimony that's saying there's no issue here. And on top of that,
Spouse a physician?
no.
So sauce for the goose would be sauce for the gander, right? The lay observations of the decedent's widow would be entitled to the same force and effect as the lay observations offered by Mr. Kearns, wouldn't they?
Well, the lay observations of Mr. Kearns, I see my.
Sorry, the 3 individuals who put affidavits in support.
So if I can respond to Your Honor, and then I have just one last point if I can make. With respect to a spouse that's living with the testator, living with Mr. Kaufman, no, I actually don't put Mr. Kearns' views on the same level as Mrs. Kaufman, or with respect to those 3 individuals. Their affidavits are summary, and I respectfully submit to the court that they don't have weight. And then when you look at you have a number of factors that are in the record, including, for example, the Auchincloss affirmation, where he explained they met with Mr. Kaufman multiple times. Mr. Kaufman explained to him he wanted to remove Mr. Kearns from the fiduciary position. They followed all of the rules of 1408. There's 3 witnesses to the two instruments that only did one thing, and that's that they removed the fiduciary. Mr. Santoro, when he says that it changed the cap on commission, that's not accurate. And that was dealt with by surrogate mayor. I asked you to look at our briefs and the record for that. But I would like to just end, if I may, Your Honors.
The cap,
Excuse me?
amendments in 2017 amendments did not affect the cap? Didn't it remove it and replace it with a reasonable amount to be accorded?
No, that was in the actual will and trust. That's in the actual will and trust. The December 2017 codicil and trust amendment just removed Mr. Kearns, removed Ms. Goldweber, and replaced Bessemer Trust Company. Bessemer Trust Company's right to the compensation, even if it's stated in the codicil and the trust amendment, it was stated in the original will and in the trust. So in other words, the original will and the trust had the concept and it didn't have any prohibition against a corporate
Are
fiduciary.
you talking about the distinction between individual fiduciary and the
Correct,
corporate fiduciary?
correct. And that's why, if I just may just briefly. Yes.
Your friend mentioned, if I understood him during his argument, that the identity of the fiduciary here would be important because the beneficiaries would be one or more charitable causes, right? And so in that regard, is it material, the identity of the fiduciary, because that person will be exercising judgment over the charities to which or foundations to which the estate will go?
No, not in this case, because the prior versions of the charitable trust had different trustees at different times. It didn't always have Mr. Kearns, and there weren't very specific directions in the trust instrument to say where monies are supposed to go at the charitable foundation. And frankly, appointing a corporate fiduciary, an institutional fiduciary, is a much more logical and rational choice than in all these other cases that are cited, for example, by the appellant, where the draftsman or the nurse or the caregiver was involved in the codicil or the trust instrument or the trust amendment. So respectfully, no, it's not there. And interestingly enough, Mr. Kearns, in his petition to the surrogates court or in his motion for discovery, does not actually allege that he has unique knowledge that it's him that needs to be in place in order to fulfill the mandate of the charitable foundation.
You have 1 minute. You said you wanted to make another point.
Thank you, Your Honor. I'll be very brief. We've talked about the guardianship proceeding. We talked about Mr. Siegfried or Mr. Barbuti, Mr. Meyerowitz. We did note on the record before the surrogate at record site 49 to 51 that Mr. Meyerowitz signed the cross petition to dismiss the guardianship proceeding and was representing Mr. Kaufman along with Debevoise and Plimpton, challenging the guardianship proceeding. But also, prior to the guardianship was started on August 7th, on August 1st, Mr. Kearns wrote to Mr. Kaufman asking him to sign a multi-million-dollar guarantee. So when we talked before about how much weight should have been given to those three affiants, there are a number of priority facts in the record, including Mr. Kearns's just 6 days before he starts the guardianship proceeding, that he's sending a multi-million-dollar guarantee to his client to sign.
Thank you.
Thank you, Your Honors.
So just a couple of points.
So, Counsel, my colleague initially asked you what it is that you would be seeking other than the commissions, right, that you were entitled to? That's what you're seeking, is that correct?
No. My client is seeking to serve as trustee of the trust.
For those commissions, right? So that you would be paid the commissions?
No, so that he can serve in the manner in which the decedent wanted him.
Okay, so where in the record, or what have you set forth that shows that he would be acting at the behest or carrying out the wishes of the decedent?
He would be duty bound to follow the decedent's trust and the terms of his will in terms of the disposition of the decedent's assets. His assets would fund, the residuary estate would fund the trust.
The only thing that he has to, other than, this, what you've just said, the only thing that he benefits from really is the statutory commissions. Like, he's not gonna get anything else. And if the other parts of the will weren't changed, right? It was just the fiduciary?
The fiduciary was changed, as well as the effect of the change of the fiduciary was to tax the charitable interest with $10 million based on the
But again, the only thing he's really recouping are the commissions, right?
right, but if we're looking at it through,
So wait, my question is,
sorry,
as a part of that, what discovery are you seeking, and how would discovery assist you?
we would conduct 1404 examinations as to the validity of the codicil, whether Mr. Kaufman signed the codicil on his own volition, free from undue influence, and with a requisite capacity. Same thing with the trust.
Let's just stop right there with the requisite capacity, because I would like for you to address the last point that your adversary made, in that there was a contract sent 6 or 7 days before to the deceased, asking for a guarantee or something like that. Why would you send such a contract to someone you don't think has the capacity, or did he lose capacity in 6 or 7 days?
That was prior to the commencement of the guardianship proceeding in August of 2017. These instruments.
What's the time period between that?
They were executed in December of 2017. If you look closely at the record, you will see in the summer of 2017, there were a confluence of factors that made it very unclear to my client as to whether he was dealing with Mr. Kaufman.
Forgive me if I'm using the wrong surrogates court nomenclature, but to what extent will the fiduciary here, regardless of who he or she ultimately proves to be, will they have discretion with the residual assets to disperse to various foundations, charities, et cetera?
They have tremendous discretion. The terms of the trust is set forth in the trust. It's hard for me to go through it.
But they're all reviewable by the surrogate. The surrogate still maintains the responsibility and the duty to review the outlays to the charities.
That's correct, Your Honor. The surrogate will review the accountings of the fiduciary. It's a question of who the decedent wanted to serve as fiduciary. We're effectuating the decedent's intent here, not my clients, not Mr. Kaufman's wife, not even the charitable interest, not even the people of the state of New York. This is about what George S. Kaufman wanted. And we believe that we have set forth significant evidence that there's undue influence and a potential lack of capacity in the execution of this will, that changes what Mr. Kaufman previously told us that he wanted over a long-standing plan. Thank you. I was talking about you, Zach.
What, have a good night?
No.